Court officer, am I audible?
Yes, sir.
Thank you, ma'am.
Yes.
My lord.
Kind permission. Report to last day today in the proceedings. I have filed application with regard to recall of PWR for further class. That application is rejected. I prepared the petition before the call about. Afterwards, my case is not listed, but the family court is proceeding day today.
Which year is this?
It is 25.
Notice is served on the respondent.
Third, the respondent.
Yes, let's reflect. Monday. Yes.
My lord.
Doing a memo, posting memo. Samraj matter, 4 months. Samraj matter, family court matter. Maintenance is granted to the wife, 50,000. Respondent approached High Court and reduced to 25,000. Even that is not paying, Your Honor.
Yes.
My lord.
Your Honor, it may be after 10th, it may be posted, Your Honor. I will submit argument.
Oh, date also you have given.
No, Your Honor, I left to Your Honor's discretion.
Yes.
It is my submission.
Yes.
My lord, I am appearing for the respondent number 2, Oriental Insurance Company. In MFA 15/4/25, you have given judgment decree. There you have mentioned as insurance company has to pay full liability instead of respondent 1 and 2. So modification we have already.
Yes. List it tomorrow.
Okay.
Give it to her. As per the court's convenience, she will give them a list.
Fourth list, refer to Lok Adalat, serial number 3, it is not settleable. That's why.
No, we'll call it. So whatever, some of the matters which have to be deleted, will delete.
Page adjournment, page number 1, page number 2, serial number 4, page number 3, serial number 5, 6, page number 4, serial number 7 to 9, page number 5, serial number 10, 11, page number 6, serial number 12 to 13, page number 7, 14 to 18.
Your Lordship, serial number 15, Your Lordship. Serial number 15, My Lordship, may I request for an accommodation of 10 days, Your Lordship.
Why?
Because there are 2 more claim petitions which have been dismissed before the MSCT of Andhra Pradesh, and only this claim petition has been filed here. So I have sought for the records of those 2 cases and also have informed the other side, Your Lordship.
No, how it will make any difference?
Your Lordship, those claim petitions have got dismissed, so I have sought for the order copies of those 2 cases to know on what grounds they have been got dismissed.
This MFA is, this MVC is allowed.
Pardon, Your Lordship. This MVC was filed before this honorable, jurisdiction of this Karnataka state, Your Lordship, filed before the MSCT at Bangalore, and whereas other, yes, Your Lordship, allowed in part.
Yes, list the matter on 8th of October.
Organized, Your Lordship.
Yes. Huh? MFA.
That is in list number 1, I am calling list number 1. List number 2, page number 2, serial number 10, page number 3,
Serial number
18.
Serial number 6, my lords. We have filed a memo for withdrawal. The matter is settled between the parties in the matter.
The memo.
Yes, my lords.
You have a copy of
Already
it?
we have filed it, my lords.
You have a copy of it?
No, my lords, I don't have it.
We'll call it when the matter.
Serial number 16.
Huh?
Want to secure some documents, my lord. Kindly have it on next week.
I appealed for the petition on 23rd of August, but a detailed order was passed, where the father was there to pay the school fee of the child. So he ascertain and then make a submission. But the order sheet only records that at his request matter has been adjourned. A detailed order was passed by your lordship. Also, what steps the father had taken to establish a bond with the daughter, 15-year-old child, read the psychologist's report.
That was recorded by the court.
Yes.
Then
But the order sheet only reflects on one line that call on 3rd of
how can
September.
it be?
Even about the school fee.
When did
23rd of August.
tell Akshita to see on the video this thing on YouTube link? What has happened on that day? Who is the stenographer also, see? See, what happened?
Look, serial number 16.
He said what is to be done?
But they want time, but they've not paid the school fees so far as in terms of your lordship's direction.
Party is not in station, my lord. We want to secure
We'll
the.
have it on Tuesday. This is matter on Tuesday. The request of land counsel, the respondent, no further time will be granted. It is submitted with the land counsel, the petitioner, that though an elaborate order is passed in the court, but the uploaded order shows that the matter is adjourned. Ask them to look. Yes.
Serial number 16, my lord.
Mm.
The writ petition, I may be permitted to withdraw the petition because before the trial court, parties have compromised.
Memo,
I'll file the memo.
take that.
Memo is good.
I'll fill,
You will give.
write and give,
She is still writing.
Then when the matter is called, then you can give.
please.
My lord, serial number 17, my lord.
Mm.
Kindly 1 week time, my lord. I
The
inform
number?
the other side. Serial number 17, 17.
You appear for?
I am petitioner, my lord. I inform the other side, my lord.
Why you want time?
My lord, my senior is inconvenienced. Kindly 1 week. Any short accommodation.
I will not extend interim order wherever adjournment
Please,
is
my lord.
sought.
Interim, my lord. Extend, my lord. Next
Will
week,
not,
next date, I will argue, my lord. Please.
I'm repeatedly telling, don't ask for adjournment. This is matter,
Any short accommodation.
November 24th.
Interim, my
And
lord.
no,
Kindly.
interim order not to be extended.
My lord. Please, my lord. Kindly illandra pass for my lord. Please.
Let it come. Yes.
Page number 4, serial number 19 to 27.
Serial number 19, the lordship was directed to produce the revised salary certificate. Today I have collected the salary certificate from the court. I will file the register and I will let my listed on 11th or 13th. Serial number 19, my lord.
Authorized PS.
Nice.
It's a matter on 22nd
Much obliged.
at the request of land counsel for the petitioner.
Page
My
number 5.
My lord, serial number 23, my lord. I appear for respondent, my lord. My lord, I have filed wakalat on 14th, my lord. Kindly grant 2 weeks time to file objection, my lord. I have informed the other side also. We came on appearing.
So that I understand. What objections in a writ petition? That's what I'm repeatedly telling each advocate. What objections you will file? Court will only be considering the whatever is the impugned order. That's it. No other document, no other new things. If they have filed any other new things before the court, I can understand you want to file objections to that. It hardly takes 5 minutes for all these writ petitions. Unnecessarily we
agree,
are
my lord,
keeping
I
it
agree.
pending. There is a stay in their favor. There is a stay in their favor. Unnecessarily you are asking adjournment. That will continue for some more time.
My lord, kindly have it next week, my lord. I go through the
Because every matter cannot come next week.
week
List the
of next
matter,
any date, my lord.
list the matter on 15th of September.
Much obliged. My lord, 15th instead of 16th, my lord. 16th,
Whenever you want. Yes,
16th, my lord.
next.
Obliged.
Page number 5, serial number 28 to 34. Page list number 3. Page number 2. Page number 3, serial number 12.
Lordship,
Page number 4,
Lordship.
13 to 15.
one submission, my lordship. Serial number line, list number 3. My colleague is underwent for an angiogram, my lordship, from last Monday, my lordship. Kindly after 3 weeks.
One.
List number 3, serial number 9, my lordship. Here is a
Enter.
B.S. Mahendra, my lordship. I am for the petitioner, my
It is
lordship.
submitted, but that the land counsel for the petitioner is unwell. When do you want?
Lordship, after 3 weeks, any date, my lordship.
This is matter on October 15th.
Grateful, my lordship.
Look at it, interim order is there extent. Yes.
List number 4 for referring to local adalat matters.
My lord, I say serial number 11, my lord. Serial
One
number
minute, 1 minute. Token in respect of since postal server insufficient.
My lord, serial number
See-
5, list
1
number
minute,
4.
1 minute it will be called. Each matter will be called. First item, step shall be taken within a week, default order. 1. Next 2, you furnish to issue notice on for first time. 2 also, same. 1 week, default order.
3 my lord.
3 also same. 4,
And so for the
steps shall be taken. Necessary steps shall be taken within 10 days, or else the appeal shall stand dismissed. Next, 5.
5, my
5.
lord.
This will be referred to the Lok Adalat 5.
My lord, it is a owner liability. I've got stay order, my lord. I'm appearing on behalf of owner of the vehicle. Yeah, dispute
This
is
is
there.
part
my lord.
of, some other, give a date for this. 5.
Till number 6.
6, it will be referred. 6, Lok Adalat. 7,
7.
Lok Adalat. No, nothing, is Pradeep is there. Lok Adalat.
Till number
8,
8.
Lok Adalat.
Till number 9.
From 8, Lok Adalat, all final hearing matters.
Well, in serial number 11, my lord, liability dispute. It cannot
Liability
be.
is
Yes, yes.
7, delete, give a date for that.
My lord, serial number 15, my lord.
Yes,
15 is also liability in dispute.
yes, 15, delete, give some date for that.
Please, my lord.
Yes.
List number 1. Apartheid matter, sale number 1. R. Shashidhara for appellant. B. Pradeep for respondent.
Payment appeal, my lord. Enhancement of compensation and also, my lord, 50% was directed towards the contributory negligence.
No, you are seeking on
Enhancement.
and on contributory negligence.
Contributory.
See the
Please, my lord, petitioner is the
liability is on insurance company.
insurance company.
50% liability against the insurance.
that I
company.
understand.
That's the
Involvement of
insurer of
two
the
vehicles,
motorcycle.
my lord. The petitioner is, appellant is traveling in a motorcycle bearing K-17 EY 4999 as a pillion rider, my lord. The other car bearing number
You're a
K-64.
pillion rider. You're a pillion rider.
Pillion rider.
What is contributory negligence on the part of pillion rider?
My lord, there is 2 vehicles for involved in the alleged accident. Both the insurer and owner in a car, my lord, there is no insurance. So far as car is concerned, owner of the vehicle has made a party to the proceedings, my lord. And I am the insurer of the motorcycle, my lord. Initially, my lord, the FIR, which was lodged against the driver of the car.
No, that we will go that we will see from the order. He's a pillion rider.
Please, my lord.
What is the
But
contributory negligence?
the contributory negligence not fixed against the pillion rider, against the rider and owner of the car, my lord. Driver and owner of the car.
Is a pillion rider.
Please, my lord, negligence has not fixed against pillion rider. The compensation has been awarded, directed the insurer of
50% by the insurance company.
and 50% against the owner of the car.
Then what is saying contributory negligence?
Yes, my lord.
It's not contributory negligence.
Tribunal, my lords, apportion the negligence, my lord, between the two vehicles. That is not permissible under law. The initially tribunal votes that, my lords, all the respondents, rider, owner and owner of the car are jointly and severally liable to pay compensation. Once the tribunal has votes that, my lord, all the tortfeasors are jointly and severally liable to pay compensation. Tribunal is not permissible to
Please
apportion
come to that
the.
finding.
Please.
Let us read that.
Para 29, my lords. Page number 27. Admittedly, respondent number 2 is the owner and respondent number 3 is
Paragraph number 27.
29.
Yes.
Admittedly, respondent number 2 is the owner and respondent number 3 is the insurer of the motorbike.
You are a pillion rider in this motorbike.
Motorbike. The respondent number 1 is the rider of the motorbike. The respondent number 4 is the driver of the car. The respondent number 5 is the owner of the car. It is an admitted fact that the car was not insured at the time of accident. By applying the principles of master and servant, petition as against respondent number 1 and 4 is liable to be dismissed. The respondent number 2 is the owner of the bike. Respondent number 3 is the insurer of the motorcycle. The respondent number 5 is the owner of the car. Hence, respondent number 2, 3 and 5 are jointly and severally held liable to pay the compensation awarded to the petitioner at the rate of 6% per annum from the date of petition till realization. It is an admitted fact that neither the owner of the bike nor the owner of the car have challenged the charge sheet. As per the charge sheet, due to rash and negligent driving by the motorcycle rider and car driver, the accident has occurred. As such, this court deems fit that the respondent number 3 and respondent number 5 are liable to pay compensation awarded to the petitioner in equal ratio of 50%. This is wrong, my lords.
Once the court says jointly and severally liable, again what is this rider? No.
jointly
He
severally.
is, he has made.
He is
the-
entitled compensation. There is no dispute, my lord. He is entitled for compensation. My lord, prima facie, the FIR would indicate that, my lord, the driver of the car who was rash and negligent driving and dashed against a motorcycle. After that, my lord, there is no insurance policy to the car. The police have filed a false charge sheet against both the driver and rider.
Those circumstances, can't you recover from him? When it is joint and several, you pay the compensation. And 50% of the compensation you recover from the owner of, from the other person.
The judgment has been passed in the year of my lord. 2022, my lord. Whether they have filed execution petition against the owner of the vehicle, owner of the car regarding that 50%.
And they were recovered.
I don't know, my lord, whether they have filed or not.
I'm not aware that,
Execution.
my lord, I'm filed.
Well, if they have filed execution petition, because my lord, the car involved is a Mercedes Benz. The for 2 lakh and 1 lakh, that is not a big amount for the owner of the car.
Get instructions on that. Tomorrow we'll take.
Please.
This is matter tomorrow. Yes, next.
Number 2. Bill number 2, Siddheshwar NK, for petitioner R. Shashidhara.
Appellant.
Serial number 2, my lord,
Huh?
serial number 2.
Huh.
I am representing the claimants, my lord. In this case, my lord, tribunal, what's that, my lord, the appellant, respondent number 1 is liable to pay compensation. The letter friend submits that, my lord, the charge sheet filed against the deceased himself. And none of the respondents for the tribunal taken this contention, and no issue was framed by the trial court regarding this issue, my lord. This issue was not dealt with by the trial court, my lord. It will be remanded back to the trial
There is
court.
a question of remanding. No.
Otherwise,
Your document is your document, is it not?
my document,
Then-
charge sheet is filed against deceased, my lord. If my lord is possible, I will convert it to 163A, my lord. One opportunity may be given by remanding the matter to the tribunal.
Initially, my lord, I sought for a remand because, my lord, I was not, my lord, filed a statement of objection before the trial court by my advocate. My lord, the finding of the trial court is dealers
What
are.
is the income of the deceased according to you? What is the income of the deceased according to you?
15,000, they have taken
Not earning, my lord.
15,000.
So,
Age number 20,
So your 163, converting it to 163 also will not arise. Because you're saying your income is 15,000 per month.
I will make necessary amendments, my lord.
You can't in the light of the settled law. It's just, let's not do it as a matter of,
Nobody's, this issue is not dealt with.
because
One opportunity may be
please
given, my lord.
understand, if it is necessary, we'll definitely grant. No, 163A, it cannot be. Because your income is, you have stated that your income is 15,000. It is exceeding the limit. So you cannot file 163A.
I can amend the.
You cannot, that's the law.
How, my lord?
You cannot amend it. You cannot amend the pleadings. What is the judgment?
That is,
What is the judgment, Mr. Raju, some Dhiru, some Patel, something is there? That the judgment of the Supreme Court that you cannot do it.
Our division bench judgment is also.
Later, the Supreme Court judgment is, but our division bench judgment is contra.
My friend is aware, he just wants to take a chance.
He's trying
I
to,
can also, my lord, withdraw before the withdraw with liberty to file fresh petition.
let's not do it.
Expand it to the trial court.
Where there is a scope, court will do, not like that. It's not a routine practice. Yes, please come. Agreed with the award passed in MBC number 167 of 2017, dated 4th March 2022. Whereby the tribunal had granted compensation of an amount of rupees an amount of rupees 14,85,800. Both the insurance company as well as the claimant are before this court. Insurance company's appeal is MFA number 2530 of 2024, and the claimant's appeal is MFA number 4030.
Owner appeal. This is.
Owner, MFA number 2530 of 2024 is the appeal filed by the owner, not the insurance company. MFA number 4032 of 2022 is filed with the claimant.
My lord, I am not the owner. I am neither the owner nor the my lord. Either this is
Is
the.
filed by a,
Thank
MFA number 2530 of 2024 is filed by the respondent number
One.
Respondent number 1 in the
Who is the
MVC.
holder of a vehicle?
Respondent number 1 in the MVC. MFA number 4032 of 2022 is filed by the claimant seeking enhancement of the compensation. Then counsel appearing for the appellant of the respondent number 1 submits that he is not the owner of the vehicle at any point of time, and without any basis he has been pleaded as R1, and the court has fastened the liability on the appellant. It is submitted that the police have filed the charge sheet against the deceased as the accident had taken place because of the rash and negligent driving of the deceased. When the deceased himself is responsible for the accident, he cannot claim compensation. This particular aspect was not considered by the court. It is submitted that if the matter is remanded, he would be able to adduce evidence. Next part, when counsel appearing for the claimant submits that in spite of giving an opportunity to the appellant, R1, he has not contested the matter. Hence, question of remand at this stage would not arise. It is submitted that nobody has raised the issue that the claimant himself, the deceased himself, was responsible for the accident. In that regard, no issue is framed. And if this case is remanded to the court, he would be able to contest the matter, and if necessary, he would be converting this application into under 163A. As he submitted that he also requests the court to remand the matter, giving opportunity to both the parties. You appear for?
Respondent number 3, my lord. I am the original dealer and sub-dealer has taken vehicle. For that, we have adduced
Counsel
evidence.
appearing for respondent number 3 submits that he is only a dealer.
Original dealer, because sub-dealer is also party, respondent number 4.
Dealer, and they have given it to the sub-dealer.
Yes.
And they have no responsibility, they have no obligation to pay the compensation. Court has fixed a liability on whom?
Against me, my lord.
Against
me.
And
has
my lord,
rightly-
in para 15, my lord, clearly stated
Court has
that
rightly fixed the liability on the appellant here in next para. Having heard the counsels on either side, peruse the material on record. This court had perused exhibit P5, the charge sheet, which is filed against the deceased. On this ground alone, the deceased is not entitled for, the LRs of the deceased are not entitled for compensation. Then counsel for the petitioner, the counsel for the claimant submits that if the matter is remanded, they would be converting this into an application under 163A. This court has perused the claim petition. As per the claim petition, the income of the claimant, the income of the deceased is 15,000. In those circumstances, even under 163A also, they cannot file an application. In those circumstances, no useful purpose would be served in remanding the matter. Hence, as the claimants are not entitled for compensation, as it's as the negligence is on the deceased, the award passed by the tribunal in MVC number 167 of 2017 dated 4th March 2022 is set aside. The amount in deposit, the appellant is at liberty, and the set aside and the appeal is allowed, and the amount in deposit, the appellant is at liberty to withdraw. It is here or before, you can.
Here, my lord, I have paid, my lord, 25% plus 25,000 I have paid.
You are at liberty to
Liberty,
withdraw.
please.
Yes.
Oblige.
Consequently, the claimant's not consequently, claimant's appeal is dismissed. Yes, next.
For dismissal matter, serial number 3. Sadashivaya KG.
Appear for the appellants in 2961 of 21.
Appear for appellant in 3.1, my lord.
Yes,
Respondent.
yes.
The case where, my lords, two vehicles were involved in the accident and out of which, my lord, the owners appeal, my lords, in
To
2961.
appear for whom?
In 2961, my lords, the liability is unfastened on me. The legal heirs of
The owner of the
please,
vehicle.
my lords.
And you are for the claimant.
Yes, please, my lord.
You are questioning the liability on the owner.
We only
Or
for
you are seeking
enhancement.
for enhancement.
Enhancement and liability also, my lord.
Liability on what ground?
My lord, there was no deal at the time of accident, my lord.
That's the only ground.
Yes, my lord.
Please come to that, show that particular portion of the order.
Yes, please.
There are 15 of the judgment of the trial court.
Para 15.
Let's prior to that, may I make one submission, my lord? I filed an IA, my lord, wherein I produced the additional document, which is the driving license, for the reason that, my lord, they say I was not having a valid and effective driving license as on the day. It is not the case that I do not possess the driving license, but it was not effective is their ground. For that, my lord, to substantiate that
So
fact,
how would, how it will alter the situation?
my lords, as per the driving license, my lord, admittedly, my lord, in the court below, I have not tendered my evidence and I have appeared before the court and substantiated these facts.
No, even as per that also, according to you, you are not having a license.
I was possessing a valid license is my contention.
Oh.
To that effect, my lord, I produced additional evidence by way of an affidavit under 41 Rule 27 before this court, my lord.
When did you file?
On 2924, my lord, it is marked as IA number 1 of 24.
29?
29/2024, my lord, before this court.
Copies are served on you?
Yes, please, my lord. It's been served.
Yes. This is Sita Ramarao.
Blood, it is
Was the
not
copy
showed
served
on me.
on you?
No, he has not given the alleged valid and effective driving license to me.
Serve a copy on
Please,
you.
my lord, I shall do that.
The land counsel for the appellant owner submits that he has filed an application under 41 Rule 27, wherein he has placed before the court the driving license of the driver of the offending vehicle. Land counsel for the, and it is submitted that they have filed, he has filed it in the month of September 2024. Then counsel appearing from the insurance company submits that the same is not served on him. The same shall be served on the counsel, and if objections, if any, shall be filed within a, shall be, you have to serve it by today.
Please,
It
ma'am.
shall be served by today, and if any objections, if any, shall be filed within 2 weeks from there on. This is matter on 26th of September.
Dates.
Much obliged.
Cell number 4. Niraja Karan. This is a paper publication idea.
For the
I have
One of
filed these
25
two
substituted
applications.
service of notice
By
proposed to R5.
Please, Milords, R4 and R5, Milords.
IA number 1 of 25 C is ordered. Next, IA number 2 of 25, that's also, yes.
that draft honor before 16/9 and the hearing date on 8/10.
Yes.
Lord, I have filed an application for release
Withdrawal
of
of the
amount.
money.
Release of amount.
Milords, I'm challenging the liability, Milords. I'm only a financial institution.
They have
My
not appeared
name
before
is-
the tribunal and
We'll see.
not take any
Yes.
contention, my lord.
We will see, Mr. Counsel.
Cell
Yes.
number 5.
Obliged.
My lord, a week's time may be granted in connected appeal, my lord, to take steps to the pillars
4.1.
of the thesis, R2, my lord.
This is done.
This is the
The steps to be taken in the next matter, that is 4.1, for taking steps in respect to the deceased R2, 10 days time is granted, default order.
Please.
Yes,
Cell
5.
number 5. Ravi.
Insurer appeal on
For the
liability. DL, please,
respondents,
Lord.
claimants.
Girish
One
Baldare.
submission, serial number 5, MFA number 6587, not linked to this case. This is another case.
Serial number 5.2, my lord.
Is not connected with this.
Not
No, it should not be connected, my lord.
Huh?
It has to be delinked, my lord.
That's what, every time whenever they say this number, that number, I ask the advocates to
I have
write
put
it on a
in.
paper and give. Otherwise, this is how it happens.
I have written it, my lord. I'll pass it.
We will hear these two.
This I'm ready. I'm ready.
Hear these two, we will delete this.
5.2 may be deleted, my lord.
Delete 5.2.
ಬೇರೆ
Yes, argue.
Madam.
Yes. You are on what ground?
No, DL, no DL. Pay and require order to be passed.
Yes.
And
You are-
no valid DL anta, only in respect of R4, but the liability is fixed on R3. R1 was driving the school motorcycle. The deceased was a pillion rider. The liability fixed on R3. R1 was having a DL. He
You
was
appear for
riding.
whom?
He was riding motor.
You appear for whom?
I am appearing for 1 to 5 claimants, my lords.
Yes.
He argued on behalf of the owner, please.
1 to 5 claimants.
ಅವ್ರು ಎಷ್ಟು ನಮ್ಮ ಮೇಲೆ ಗ್ರಿಜ್ ಇದೆ ಅಂತ ಅನ್ನೋದು. ದ್ವೇಷ, how much is that? I can't express that word, please. Appearing for the claimant, arguing on behalf of the owner. What type of practice I can't understand.
You don't have to be, don't have to feel so bad about it. Yes, let's see.
R1 held.
Please come to, you're not on the amount.
Amount, I am not.
So please come to that
Para
particular
13,
paragraph.
please. Para 13 of the judgment.
Para?
13 of the judgment. We have taken the defense, examined the officer, charge sheet against the driver of the vehicle under section. Per contra, the third respondent got examined the administrative officer as RW1, who had stated that the accident took place due to negligence of the driver of the car, driver and so and so. They have not liable to pay the
The vehicles involved,
Please, ma'am.
only one vehicle.
One only.
Car.
Motorcycle and
Motorcycle
car.
also.
Dash.
Motorcycle is, that's driven by the
He is the
R1.
pillion rider.
First respondent.
claimant.
I am for the
No.
seventh respondent, my lord. Two vehicle involved accident, motorcycle and car. Rash and negligent motorcycle, but car not involved accident. Due to negligence of the motorcycle, is a death, deceased Sudeep. R7 is not.
According to you, the driver of the motorcycle is not having a valid driving
Please,
license. Let's see. The driver of, or driver or the owner of the motorcycle is respondent.
One, Shiv Kumar.
Who represents Sukumar? You represent. Let's see.
Charge sheet also
R7.
filed against.
K. Nagaraj.
Third and representative.
R7.
Owner.
Admitted. Charge sheet also filed against respondent number 1.
That's what the driver, the rider of the.
Motorcycle.
Please come to the finding with regard to liability.
Liability ಬಗ್ಗೆ they are not at all discussed by the learned judge. There are 13 ಅಲ್ಲಿ have discussed.
More particularly, para 27 millets. 27. Page 27, para 27.
Therefore, the respondent number 2 being the owner and respondent number 3 being the insurer are both, what is this?
Claim dismissed against that New India Assurance and their owner, please, insurer of the car.
Please come to the cost item,
Cost title of the appeal memo or judgment, please.
judgment.
Judgment.
Shiv Kumar is the rider of the motorcycle, please.
Hmm?
Rider of the motorcycle.
He is a motorcycle rider.
Rafiq Salman so and so is the owner of the motorcycle. We are the insurer of third respondent in United India is the insurer of the motorcycle. And this Nagaraj is the rider of the car. And Yakub is the owner of the car. And the policy holder, Haryana, R6 is Haryana is the policy holder. And New India Assurance is the insurer of the car. Liability is against us.
So, the respondent number 3 has admitted
Please,
that they have issued policy in the name of respondent number 2.
please,
And they have
owner of
not
the
to
car.
set policy as per exhibit R1.
Please.
On the date of accident, the vehicle of the respondent number 2 was driven by respondent number 1 and therefore, so No, you are saying that there is no valid driving license.
Please,
What is the charge sheet is filed under which provisions?
not 180, 181 both.
It's
Owner
there.
and driver and owner of the offending vehicle.
Yes. we
Yeah,
have
pass
to
it to-
pay and recover. No, at this point, already charge sheet is filed, everything is over. What is that to be verified now? 180 and 181,
Please, can I pass it to Madam? Sahib.
not necessary. Then next come to the compensation.
I'm seeking enhancement of compensation. My lord.
What is the age,
Age of the deceased 25 years, my lord.
occupation,
Occupation coolie, my lord.
earning how much according to you?
According to me, 15,000 per month. my
Which
lord.
year is the accident?
Accident in the year 2009.
How much should be taken?
14,000.
14,000.
14 and half.
19 accident too.
January
Chart
2000.
ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
14. 14 for the entire 2000.
Please, please.
Is a bachelor?
Bachelor.
50% will be deducted, please.
What is the multiplier?
Millets.
25,
Multiplier.
18 multipliers. This was 18. 25
Multiply
years.
18.
It's coming to 21 lakhs. What was the income taken?
There 10,000. it was
10,000 they have taken by the MSCT.
Future prospects were considered.
30%
considered.
has been added.
Only 1 lakh
That's
15.
why this is the difference. It's coming to 21 lakh
Ah.
16,800. Both mother and father are the claimants.
Yes, Millets. And sisters.
And
Three sisters.
3 and 4, 5, please, they are not entitled the loss of consortium because if they are siblings. Therefore, they are
Consortium, why not?
40,000 each, please.
That's a consortium, why not?
They are not, the
25 years.
judgment of this honorable court today I have not brought it, my lord.
Mm.
Siblings are not entitled the consortium. I will submit the judgment also, please. Today, I
There is a
have-
judgment of the Supreme Court.
no, by our division bench of High Court.
No, there is a judgment of the
The
Supreme
judgment of
Court.
the Supreme Court entitled the consortium.
They have granted. So why will we consider division?
So I brought your lordship, please.
No, no, no. We
Please.
will consider Supreme
Please.
Court judgment. So 4, 5.
3, 4, 5. 3, 4, 5 sisters.
You know?
Sisters claimants.
But future pass 30 or 40, please. Huh?
It is like consortium is consortium.
No, future pass.
40%.
The tribunal has given 30%.
It's coming to 23 lakhs 82,800.
At 50, our 50%, please. 50%.
Deducted. 14,000 is the income. 5,600 would be 40% future prospects.
Please, ma'am.
It comes to 19,600.
Please, ma'am.
50% would be 9,800
Please, ma'am.
into 12 into 18. Yes, please come.
23 lakh 80.
Agreed with the award passed in MVC number 468 of 2019, dated 18th February 2022. Both the insurance company as well as the claimant are before this court. The insurance company's appeal is MFA number 4516 of 2022, and the claimant's appeal is MFA number 4965 of 2022. Before that, in a docket order, in a 5.1, A number 1 of 23 is filed to condone the delay of 43 days in filing for the reason stated. The delay is condoned. Yes. The claim petition is filed by the parents and the three sisters seeking compensation of an amount of rupees 25 lakhs for the death of the deceased in the accident. According to the claimants, the deceased is earning 15,000 per month. The tribunal, when it comes to the rash and negligent driving of the driving, it is held that the accident had taken place because of the rash and negligent driving of the driver of the rider of the motorcycle, as the same is insured with the third respondent. The same is insured with the appellant insurance company. It was held that the appellant insurance company is liable to pay the compensation. When it comes to the compensation, the court had considered the income at
10,000.
10,000, and by granting 30% future prospects, had granted compensation of an amount of rupees 13,14,600 as per the table given below. At paragraph number 26, there is a table extracted. Learned counsel appearing for the appellant insurance company submits that after a full-fledged investigation, police have filed the charge sheet against the rider of the motorcycle, and as per the charge sheet, the offences are under section 180, 181 of the Motor
Both,
Vehicle
please.
Act, and section
Please.
the offences under
Please.
section
180, 181 and 180, both please.
Offense.
No DL, please.
No valid.
Other section, please. 279, 338, 304A.
take that and
PCR is there.
use that. Under section, the charge sheet is filed under section 279, 338, 304A of IPC, read with 180, 180, and also under 180, 181 of the Motor Vehicle Act. Then counsel submits that the filing the charge sheet under section 180, 181 of the Act clearly shows that the driver of the offending vehicle, the rider of the bike is not having a valid driving license. Once, if he's not having a valid driving license, the insurance company, the principle of pay and recover will apply. Next para. Learned counsel appearing for the claimant submits that the accident had taken place in the year 2019, and the court had taken, when it is a contention that the claimant is earning, the deceased was earning 15,000, court had taken the income at 10,000. His age is 25 years. As per the settled law, he is entitled for the future prospects at 40%, but the court had granted future prospects at 30%. Even under the conventional heads also, the amount that is awarded by the tribunal is not a just and reasonable compensation. Next para. Having heard the counsels on either side, there is a material on record. First, coming to the aspect of liability, as a charge sheet it is filed against the rider of the motorcycle under section 180 and 181 of the Motor Vehicles Act, along with the other offences. It is clear that the rider of the motorcycle is not having a valid driving license. In the light of the law, in the light of the law later on the Honorable Apex Court in Swaran Singh's case, the principle of pay and recover will apply, and the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Next, coming to the compensation, the deceased was aged about 25 years. As this accident had taken place in the year 2019, this court is taking the income at 14,000. Future prospects at 40% will come to 5,600. That is 19,600. As is a bachelor, 50% has to be deducted. And his contribution to the family would be 9,800 into 12 into 18. Under the head of loss of dependency, is entitled for an amount of rupees 21,16,800. As the parents of the three sisters, 5 people are entitled for loss of consortium, that is 5 into 44, 2,20,000. And towards central expenses, 36,000. And in the light of the law laid down in Mekala versus so and so, 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 23,82,800, which is payable by the insurance company, and the same shall be recovered from the owner. The enhanced amount shall carry 6% interest. Next, the amount accordingly, the appeal of the claimant, that is so and so, is partly allowed by applying the principle of pay and recover. The appeal of the claimant is partly allowed by enhancing the compensation from 13,14,600 to 23,82,800.
On submission, interest for entire amount for 6%.
So entire amount shall carry 6%.
On behalf
of, Millard,
And one minute.
Before the tribunal, 9% interest was given.
The appeal is there in his contentions of the insurance company. The tribunal has granted 9% interest, which is excessive. So their appeal is allowed both on principle of pay and recover, as well as the interest is reduced from 9% to 6%. Yes.
The amount deposited.
5.2, dealing 5.2 from these appeals and post along with, give her that number.
The amount in deposit kindly transfer to the tribunal.
Permitted to withdraw.
Right? They have to transfer to
It
them.
may be transferred
Before the
to,
tribunal.
Please.
Yes, next.
please, much obliged.
On behalf of New India, only formal party.
Yes, sir.
Serial number 6. Tripadipati.
Yes.
My lord, I am for appellant.
Yes,
I
it is
filed an
ordered.
IA.
Ordered. Next, 7.
Serial number 7. Serial number 7.
Yes.
BP Radha for appellant.
I appear for respondent number 1.
Yes.
The appellant case also preferred this appeal, argued by the order passed by the trial court holding entire liability on the KSRTC bus, my lord. Because accident took place in the midnight, and the KSRTC bus, while overtaking the vehicles, it hit the lorry, which is parked on the highway unmindfully without taking any precautionary measures to make note for the highway travelers that the said vehicle was parked due to puncture. So on that count only, I am before this court. It is purely due to the negligence act of the lorry driver who unmindfully stationed the vehicle.
Let's read that finding.
Yes, ma'am.
About what is your contention, whether the parking lights are on or not.
No, ma'am.
Let's read that. Which paragraph?
Para 22.
Yes, please read.
In the cross-examination, it has been elicited.
Other appeal is of the claimant.
Yes.
Yes.
The cross-examination, it has been elicited by the learned counsel appearing for the petition that since the accident had been occurred only due to rash and negligent driving of the KSRTC bus by its driver, and also exhibit P7 charge sheet has been filed only against the driver of the KSRTC bus, which is admitted by this witness on perusal of the evidence of PW1, RW1 and RW2 and exhibit R1 and R2, it is forthcoming that the manner in which the accident was taken place and involvement of both vehicles, especially in exhibit R2 sketch, the place of occurrence shows that the accident was occurred. The involvement of KSRTC bus itself is not shown at the same time. The place in which the insured lorry bearing number so and so is shown.
So where is this all the submission that there was no traffic? There is no parking light. Nothing.
Yes, my lord. That is, we have given evidence.
Let's see your objections.
I have, yes, my lord. I have examined RW1.
Who is he?
Driver of the.
No, apart from that, your driver will give the evidence
And
as per
sketch
your
my lord.
objections. What did you say?
Objections, you had taken that contention. Have taken that contention.
Let's see.
Objections of KSRTC. And that I would like to read the evidence of our depot manager, my lord.
That will not be the basis
Because
for
the
the court.
evidence is
Charge
reiteration
sheet
of
is
the,
already against you.
no, that evidence is reiteration of the statement of objections, my lord.
Objections of the case, RTC.
And in the judgment also it has been mentioned, my lord. The contentions of the case RTC. In the judgment also it has been mentioned. It is available in judgment itself, my lord, at page.
No, I'm looking at your,
Yes,
your
yes.
objections are there. Look at your objections and tell the court which paragraph to be seen. What does the charge sheet say?
Charge sheet entirely liability is fastened on
No,
case
not
RTC.
that. How they have narrated it. Huh? You read it. Huh? Look at it. Spot sketches exhibit.
Are two, my lord.
No, here, if you look at the finding of the court says that the car and the lorry, I mean, the lorry and this bus, the spot itself is different, where it is parked.
Exhibit R to no, sir.
Left side. Accident has happened on the right side.
Admittedly, it was not on the Kacha road. Some portions of the body of the lorry was on the
Understand from the
highway
sketch.
also, my lord.
We have to understand from the sketch.
Yes, my lord.
Look at the sketch.
Some portion is on the highway also. That is
No,
our
where
case.
is the lorry? Lorry is, and where is the accident? Please, yes. Then please come to the enhancement. Where is the table? Yes, please come to paragraph number 46. What are the injuries? One fracture. Two fractures. 60,000. Next, medical expenses. As it is, 1,17,560. How many days was in hospital? Already considerable amount is granted. For 8 days, under both the heads, will make it 8,000. Yes. How much the court has granted? 12 plus 5. 17 is granted. Will make it 8,000. Yes. Loss of income during laid up period. Which year is the accident? What is the income? So 12,500 into 3. It comes to 37,500. Then loss of future income. How much was taken as income by the court?
12,500.
12,500 only.
It is correct.
So then what about, what is your submission on this? 7, loss of future earning capacity. According to the doctor, what's the disability?
18 points. One.
Doctor's
18
evidence is, loss of amenities. What is the disability to the body as per the doctor?
18.07%.
To the limb. Or to the limb.
To the
So I
whole
think
body.
for loss of amenities, amount can be enhanced. It's only 5,000 is given. We'll make it 25,000. It's coming to 5,02,000. What was granted? 4,16,005. Please come. Agreed with award passed in MSc number 192 of 2019 dated 3rd December 2021, whereby the court had granted compensation of an amount of rupees 4,16,005. The claimant is before this court seeking enhancement of the compensation by filing MFA number 5787 of 2022. The RTC, what is this? Respondent is?
Agriculturist.
No. The RTC. No, the KSRTC. The KSRTC is before this court questioning the liability fixed on the entire liability fixed on the KSRTC when there is a contributory negligence on the part of, when there is a negligence on the part of the driver of the lorry. Next, then counsel appearing for the KSRTC submits that the accident has taken place in the midnight where the lorry was parked on the road without
Unmindfully he has parked the vehicle.
the lorry was parked on the road without taking precautions, without the parking lights on, and because of his negligence, the accident had happened. And this particular aspect, the tribunal has failed to consider and fasten the liability on the driver of the KSRTC. It is submitted that the KSRTC has also examined the depot manager and driver in support of their case, and all these aspects were not considered by the court. Next para. Learned counsel appearing for the claimant submits that though the claimant had sustained 2 fracture injuries, the court under the head of pain and suffering had not granted a reasonable compensation. Further, when he had sustained 18% disability, the court had granted a very meager amount under the head of loss of amenities. And on all the counts also, the amount that is awarded by the tribunal is not just and reasonable. Next part, having heard the counsels on either side, that is the material on record. First, coming to the liability, coming to the negligence and liability, the tribunal had observed that on perusal of evidence of PW1, RW1 and RW2 and exhibit R1 and R2, it is forthcoming that the manner in which the accident has taken place and involvement of both the vehicles, especially in the R2 sketch, the place of occurrence shows that the accident occurred, the involvement of KSRTC bus itself The involvement of KSRTC bus itself is not shown. At the same time, the place in which the insured lorry is shown at remote point towards western side at the distance of 100 meters from the spot where the accident has taken place. So that the IO had rightly submitted the charge sheet against the driver of the KSRTC bus. R3 and R4 are subsequently brought on record will not take away the evidence as per exhibit R2, which are only found against the driver of the KSRTC bus. Hence, the tribunal had come to the conclusion that the accident had taken place because of the negligence of the driver of the KSRTC bus, and they are alone liable to pay the compensation. In the light of the arguments advanced by the learned counsel for the KSRTC, this court has perused the sketch and the charge sheet, which clearly points out at the negligence of the driver of the KSRTC bus, and this court do not find any reasons to interfere with the said finding of the tribunal on the issue of negligence. Next, accordingly, the appeal of the KSRTC is dismissed. Then coming to the claimant's appeal, he has sustained 2 injuries. Under the head of pain and suffering, this court is inclined to grant an amount of rupees 60,000. Towards medical expenses, no interference is possible. When it comes to the attendant, conveyance, food, diet, when he was there in the hospital for 8 days, court had granted 17,000. Considering the 8 days of hospitalization, this court is granting 8,000. Coming to the loss of income during the later period, as it's an accident of 2019, taking 2018. This court is the income is taken at 12,500 for 3 months, 37,500. Coming to the loss of future income, court had rightly considered the evidence of the doctor and rightly granted the compensation, and no interference is called for. Considering the 18% of disability under the head of loss of amenities, this court is granting 25,000. In the light of the law laid down in Mekala also so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 5,02,005. Accordingly, the appeal of the claimant so is partly allowed, enhancing the compensation from 4,16,005 to 5,02,005, and the enhanced amount shall carry 6% interest. The appeal of the KSRTC is dismissed. The amount in deposit shall be forthwith transferred.
Bill number 8, Nagaraj Hegde for appellant. P.B. Raju.
My appeal is on limited ground that as per the notification, this is receiving at 8,000 rupees.
How much?
8,000.
Court had taken? Court had taken?
12,000.
What do you say on that? It has to be as per the notification.
Not,
There is one that I gave my friend this judgment. There is one judgment of the scope following grounds. This court said there was one explanation, one section 4. That was deleted in 2009. But 412B was capital B was introduced. It said the central government can fix the income by notifications. Now, 2 notifications have been issued subsequent to 2009, 2010 8,000, and in 20 making it 15,000. This revision judgment, what this was, relying on para 24 of
26.
Because the notification is given after a gap of 10 years, so in between some.
They only said that since the 41A was explanation was omitted, there is no cap at all. Because referring to the explanation 412B, explanation and notification. What is written by judgment by law. So now I do not say that it does not bind law. I am now on another issue. Insofar as none of these judgments consider, since I have issued collected premium on the basis of the notification and 8,000 rupees, whether it should be restricted to 8,000, the balance he can recover from the owner. On that limited point, I need other judgments placed before my lord. Otherwise, in view of
No, if it is under the ECA Act, as per the policy, your liability is limited to that.
In this case, that has not been considered. Anyway, I will also will not make research on that.
No, it is limited and remaining amount has to be from the owner of the vehicle.
If it is proved.
Proof that the income is in excess of the cap, he is entitled. My only prayer is, so far as I am concerned, having deducted the premium collected, kindly restricted to this. He is entitled to more later without.
That can be considered, that plea, there, because in the other case also yesterday I passed for an order. Yes. When do you want?
Next Tuesday.
Yes, list the matter next Tuesday. Yes.
Serial number 9.
At the request of full and counsel for the insurance company. Yes, 9.
9. Prakash MH for appellate.
For the appellant, Your Lordship.
Case of death or injury.
Death, Your Lordship.
Where is the table? 20. Paragraph number?
Paragraph 34. This is for the age of 74 years.
74.
74 years.
Oh.
Only consortium insofar as.
Consortium, how many people, how many are there?
Your Lordship, with the wife and.
So now on loss of dependency, we are not going on that. Loss of dependency as it is 5,80,000. Then loss of consortium 84, 88. Who are the claimants? Wife. So 3. 1, 2, 3. But as on that day, she was there. Wife. That is, but not mother. And I mean, wife was there as on that day. Consortium. So that is not concerned. So it becomes 1, 2, 3, 4. Children are entitled for consortium. So 4 into 44. No, I'm not looking at it. It's entire fresh consideration. It comes to 1,76,000. Then 36,000 funeral expenses. Legal expenses 10,000. No, I'm not. That I'm not taking it. We'll see how much it becomes. Yeah. It is coming less than that. Medical expense. Where are the medical expenses? That was not
10,000.
That was not counted. Yes. It becomes 10 lakhs 12,558. Yes, Pradeep. 10 lakhs 12,558. Yes, please come. Agreed with award passed in MBC number 1731 of 2020, dated 27 December 2022. The claimant is before this court seeking enhancement of the compensation. the claim petition is filed seeking compensation of an amount of rupees 20 lakhs for the death of the deceased. Originally, the wife was the claimant. During the pendency of the petition, wife died, and the daughter and two daughters and son were impleaded as a LRs. The court had granted the compensation as per the table given below. At paragraph number 34, the table is there extracted. Then counsel appearing for the claimant submits that under the head of loss of consortium, the amount that is awarded by the tribunal is not a just and reasonable compensation. It is submitted that the compensation needs to be enhanced. Then counsel appearing for the respondent insurance company submits that the compensation that is awarded is just and reasonable. Next, having heard so and so and so. The court, under the head of loss of dependency, has rightly granted 5,80,000. The wife had died during the pendency of the petition, and the LRs are two daughters and a son. For 4 people, under the loss of consortium, 1,76,000. 36,000 towards the funeral expenses, and 2,10,558 towards the medical expenses. And in the light of the law later on in Mekla also so 10,000 towards the legal expenses. Altogether, the claimant is entitled for an amount of rupees 10,12,558. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 8,77,558 to 10,12,558. Yes. Yes. Which one? Serial number? 2.1. 2.1 into 2.1. No, memo is filed seeking dispensation notice to R2 and R3. Dispense with the risk of appellate. Yes, next.
Final hearing matters. Serial number 10. Serial number 10 B.
Then, my lord, appearing for the appellant in first case, my lord.
Yes. No, we'll come to your appeal first. What is insurance company's appeal?
My lord, we are disputing the policy, my lord. We have not at all issued the policy to the vehicle bearing number so and so, my lord.
Let's see the finding of the court.
Finding that, my lord, the tribunal coming to the conclusion that the owner, the driver of the vehicle who has produced one copy of the policy, exhibit R1 may kindly be seen, my lord. And exhibit R4 is relevant, my lord. My lord, the proposal form is taken from the company on 15/7/2014. How can, my lord, the policy will be issued on 9/7/2014? We have produced the policy of insurance. Owner is, my lord, Leonard Friend is owner.
Have you seen all these documents?
The conclusion is that, my lord, I have not lodged a complaint against the owner. That is the conclusion. There is no contract at all, my lord.
No, look at those documents. Both
His
of
claimant,
them.
my lord, owner is representing.
Huh?
Owner is represented, my lord.
R1 and R4 wasn't there, but R1 produced by driver of the vehicle. R5 is produced by the
What is R1 and R5?
Policy only, my lord. Wherein, my lord,
R1 is produced by them.
R1 produced by the RW1 rider of the motorcycle. That in that regard, my lord, we have contended that as on the date of accident, we have not issued the policy. They have approached the company itself by producing a proposal form, my lord. That is important, my lord. 15/7/2014, they have approached. The date of accident is, my lord, 9/7/2014.
15/7?
2014.
They have approached.
Approached.
That's a
And the same day we have issued the policy.
Proposal form.
Proposal form. The same day we issued the policy covering the risk from 15/7/2014 to 14/7/2015.
Accident happened?
9/7/2014. Even assuming, kindly see both the documents, my lordship.
Give that.
I have marked, flag it.
No, what is the action, whose signature is this? At the relevant point of time, you should have done, you
No,
can
my
use
lord,
some
exhibit
evidence.
R5 may kindly be seen.
No, I'm looking at exhibit R1.
I saw that, my lord. I
Uh.
saw that, my lord. Even assuming that, my lord. Even assuming that I have issued the such policy.
No, not assume, we shouldn't.
No, my
assume.
lord, I am
No,
just
I'm
I'm
saying we
giving an
should do
example.
something.
Please, my lord, see the coverage of that original policy itself, my lord.
Exhibit R1.
Exhibit R1 itself. It covers from the midnight. The accident taken place on 9/7/2014 at 3:55 p.m.
Oh.
There is no coverage at all in that policy also.
No,
It covers from the midnight. my lord.
No. Accident happened at what time?
9/7/2014.
No, at what time?
14. 14, my lord.
3:45.
Please, my lord.
3:45 p.m.
PM.
And it covers from midnight.
Midnight, 9/7/2014. Even assuming that that policy is valid. There is no coverage at all, my lord. Because, my lord, they have approached the company by taking a proposal form, liability only policy they have taken. There is no inspection of the vehicle is required because we are not going to give own damages. They knows that, my lord, there are policy lapses. My lord. If continuation of policy, my learned friend has to produce that previous policy when it has lapses. When he has approached. That is important.
No, even as per this policy, it comes into effect from midnight. Accident happened before that. Let us, not about findings, we have to look at the policy. Court will not give any finding contrary to the policy. Where do you get that?
And the coverage is there, my lord. 9/7.
One minute. Period of insurance. From
9/7 midnight.
No. What is it? By midnight of?
00 hours only, my lord, the policy will be issued.
It's not, it doesn't say so. From 13/21 on 9/7/2014.
From the midnight only, my lord. The coverage starts from 00 hours only, my lord. If the previous policy is there, my lord, if previous policy lapses on 8, then it is continuation of premium, my lord, then will continue. If really they have approached the company, my lord, they would have produced the receipt. If they have produced that document, on what date, my lord, he has approached, they would have produced the receipt, my lord. They will give the receipt, my lord. Or otherwise, if we taken the policy from the online also, we'll give the receipt, my lord. That is created, my lordship, that first one.
Get that? At the request of counsel for the owner of the vehicle, appearing for the owner of the vehicle, list this matter when? It's a matter on 9th of October. Yes, next.
Stage number 11. Sachin BS for appellant. Ravish.
Who is R1?
Ravishankar.
That's Mr. Ravishankar of this file.
Who is R1 in 11.1?
7.1.
Notice is not served on him.
Malats is the driver, Malats, the owner of the vehicle, Malats, offending vehicle.
Not necessary.
Not his best expert in the trial.
Then write a memo and give.
Please, Malats, I'll give them.
In 11.1, a memo is filed seeking dispensation of notice to R1. Take a memo from him. And the memo is taken on record. A memo is filed stating that the liability is fixed on the insurance company. And the notice to R1 may be dispensed with. Accordingly, memo is taken and notice is dispensed with. Yes.
That's the first matter, Malats. It's a case of accident, Malats.
Both the matters are for enhancement.
Please, Malats. That's isn't the.
Where is your appeal? Where is your appeal? Huh? No, pay and recovery is ordered. Yes.
That's case of accident, Malats. He was aged 46 years and salary certificate has been produced, Malats. But Malats, the injuries, if your lordships may kindly see, Malats, the left.
Come to the table first.
Please,
which is MBC Now, there are two MVCs.
Please, my lords.
Now, this MFA 9073 is arising out of
546 of 14.
546 of 14. Other is 545.
Table is
So
at,
let's see the table of 546.
please, my lords. Table is at internal page 36.
Internal page.
Sorry, my appeal page 36, my lords. Internal page 30.
Is it pertaining to 546?
Please, my lords.
Yes.
My lords, the injuries are my lords left tibia shaft, and he has also undergone surgery. There's a cast on his leg, my lords, and nothing was awarded with respect to future medical expenses.
Pain and suffering, what is the injury?
My lords, multiple abrasion over both the legs, left tibia fracture shaft, and he has undergone surgery and he was inpatient for 8 days.
Yes. 40,000 for pain and suffering. Then loss of, what according to the doctor, what is the disability?
My lords, doctor is not examined. Doctor is not examined.
Already loss of immunity is 20,000 is awarded.
There was a cast on the leg, my lords. My face, some nominal medical
That is
expenses.
already, that is sufficient. Without even examining the doctor, the court had granted liberally, yes, 20,000. Then
But in that event, that is all, my lords. And my lords, one more.
loss of income during the later period, which year is the accident?
My lords, it's accident is of the year 2013.
2013. Amount is 8,000.
Please, my lords.
8 into 3, 24,000.
My lords, is a salaried employee, my lords. Salary certificate was produced.
If that is, then if it's whether it is whether is that amount is you have that any benefit out of it, and
My
all
lords,
you have to
I
examine.
have taken the benefit out of it, but my lords, the trial court has committed one error. The salary certificate that I have produced is of the year January 2016. Now, my lords, in a cursory manner, they have come to a deducted amount, my lords. The 26,000 is my last drawn salary, but they have given me 19,000. 2013. So, my lords, by any stretch of imagination, no government employee will get 7,000 increment in 2 years. Somewhere around 21.
It is for you. Court will not do the guesswork for you.
Well, the court has done the guesswork and reduced it to 19,000.
No. What was the relevant 2013? Have you placed the payslip?
No, my lords. While placing the payslip, is placed salary certificate. That's the error is done. It's on my part, my
We
lords.
have to go as it is. So, then how many days you was in hospital?
8 days.
Huh?
8 days.
In that another 5,000 will grant.
Please, my lords.
Then medical expenses as it is.
As it is, my lords.
1,983. It's coming to 1,06,633. Yes. What about the next one? 545?
That's a. It's a case of accident again, my lords. But during the pendency of the claim petition before the tribunal, the claimant has passed away. My lords, the injuries, if your lordships may kindly see.
No, please come to that table.
Please, my lords. there's no table, my lords.
Para? Hmm.
My claim was that, my lords, there was a nexus between the injuries that I suffered with the death that has subsequently occurred in the year 2016.
Why they are not entitled? No, if it is a case of, because of the injuries sustained in the accident, if he died, huh? Not for the?
And he was examined on 1/14/2016. He died on 18/9/2016 after 9 months of the evidence, after 4 years of the date of death.
But they say that it is the result of the accident. Read the issue number 3, paragraph 33. While answering issue number 1. Huh? Read that. Deceased petitioner sustained has also held that legal errors have failed to prove that there was a, have failed to prove.
Lords, the injuries that he has suffered are all fatal injuries. My lords may kindly see Exhibit P6 is a wound certificate.
Not wound certificate. Why is a post-mortem certificate?
That is not there, my lords. He had suffered his fracture to his ribs, and my lords, at the time of the injuries, he has also suffered injury to the spinal cord.
No.
All 4 limbs were.
Then there should be, you should have placed a post-mortem certificate before the court.
He died out due to a heart attack, my lords. There's a doctor evidence who has treated him for the emergency admission. States that the heart attack was caused due to his inability to move. Since the date of accident, he was bedridden. Slowly, after 1.5 years, 2 years after the accident, he got minimal movement in all 4 limbs. But due to the congestion in the chest due to the fracture, he has passed.
So what is granted?
About 30,000 is granted.
Medical expenses of 27,000. Medical bills.
Nominal sum of 32,000, which was rounded after 33, was granted, my lords.
He was there in hospital for 20 days. So on that he is entitled for 20,000. This is 20,000 plus 22,000. Then we'll make it 50,000 down.
Plus, there's a doctor's evidence which says that due to the injuries there's a cause of death. But there's no post-mortem report.
Yes, please come. Now, agreed with the award passed in MFA number MVC number 545 and 546 of 2014, dated 20th July 2019. MFA 181 of 2020 and MFA number 9073 of 2019 are filed. Though 2 separate appeals were filed, as tribunal had disposed of both the appeals by way of a common order, this court is also disposing the same by way of a common order. The appellant is before this court seeking enhancement of the compensation. Side heading. MFA, MVC 545 of 2014, MFA number 181 of 2020 against MVC number 545 of 2014. In this case, after filing the claim petition and during the pendency of the claim petition, the claimant died and LRs were brought on record. It is the case of the claimants that the accident had taken place because of the death has taken place. There is an excess between the injuries and the death. The court has disbelieved the same and held that there is no sufficient material on record to show that the accident, the death is resultant of the injuries sustained in the accident. And the court has also held that in the light of the subtle proposition of the law, legal heirs of the deceased are not entitled to the compensation at the head of personal injuries such as future loss of income, income during the later period, pain and suffering, discomfort and future medical expenses, future prospects, except medical expenses, attendant charges, nourishment, food provided to the deceased. And the court has held that the medical bills are amount of rupees 22,410. He was in hospital for 10 days under the head of attendant nourishment and the transportation is entitled for 10,000. Altogether, the claimant is entitled for an amount of rupees 33,000. Next para. The counsel appearing for the appellant claimant submits that the doctor's evidence is very clear that because of the injuries sustained in the accident, his mobility, there is no mobility, and that gradually led to the heart attack. Then in that case, there is nexus between the injuries and the injuries and the death, and the court ought to have granted the compensation. It is submitted that even on the heights, the amount that is awarded by the tribunal is not a just and reasonable compensation. Next para, then counsel appearing for the insurance company as well as the owner of the vehicle. Oh, the counsels appearing for the insurance company have supported the order impugned and submits that the court had rightly granted compensation and rightly held that the principle of pay and recover apply, and there are no reasons to interfere with the award. Next para. Having heard the counsels on either side, there is a material on record. The claimant had failed to establish that there is a nexus between the accident and the injuries. No postmortem certificate is placed before the court. In that view of the matter, court had rightly come to the conclusion that there is no nexus. Then coming to the compensation, court had granted 22,410 towards medical expenses. There is nothing to interfere. The claimant was there in hospital for 10 days. He is entitled for an amount of rupees. He was there in the hospital for 20 days. He is entitled for an amount of rupees 20,000. In all, considering the injuries, the death, and all these issues, this court is inclined to grant an amount of rupees 50,000. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 33,000 to 50,000. Next, MFA number 9073 of 2019, arising out of MVC 546 of 2014. In this case, the tribunal had awarded the compensation as per the table given below. Table is at above 45 paragraph. Extract the table. Then counsel appearing for the petitioner, appellant claimant submits that the court had not granted the reasonable compensation. It is submitted that when he had sustained a fracture injury, court had granted only 20,000 under the head of pain and suffering. Court ought to have considered the salary yet.
That's
at what amount salary has to be considered according
that's
to
at 21 to 22,000.
21 to 22,000. Court ought to have considered. That is his contention. I'm asking 21 to 22,000. It is submitted that he was in hospital for 8 days, but the court had granted only 3,000 and the head of attendant and nourishment. It is submitted that on all counts the compensation needs to be enhanced. in this, the contention of the insurance companies of the same, like in the other case. Having by the counsel, there is a material on record. The claimant is sustained the one fracture for that is entitled for an amount of rupees 40,000. Court, without the claimant examining the doctor, under the head of loss and indemnities has granted 20,000. No enhancement is called for. And under the head of loss of income to the later period also, court had rightly granted 26,650 and no interference is called for. Coming to the nourishment and attendant charges, he was in hospital for 8 days, hence this court is granting 8,000. Towards medical expenses, court had rightly granted 1,983. No interference is called for. In the light of the law laid down in Mekala also so and so, towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 1,06,633. Accordingly, the appeal is partly allowed, enhancing the compensation from 76,583 to 1,06,633. Then in the last paragraph, MFA number so and so, partly allowed, enhancing from so and so, MFA number. Yes. The compensation amount shall be paid by the insurance company and shall be recorded for the owner of the vehicle. The enhanced amount shall carry 5%, 6%. Yes.
Number 12. Srinivasaya, for appellate.
Yes.
My appeal is two
Abhishek
grounds.
Kashyap.
One is your lordship. License. License.
No license.
License is there, but in view of the Supreme Court, we lost our facility of the recovery also in this case because is the auto. Because auto is having a LGB and automatically it goes.
Mukund Devgan case will apply. Next. Second round.
Next round is
compensation.
No. A policy taken by a dead person. Because the owner is died prior to the accident. He has taken the policy in the name of the dead person only.
So what will follow?
Left your lordships can decide.
It's not discretion. What's the law on that?
The law means
Why
because you can't take the policy as a dead person. Because and also we have the last brought on record. Yes, and also he has died on prior to the accident.
So both the grounds are not available. Now what about your appeal?
At least this ground can be considered.
Yes.
Fraudulent lordship. Fraudulent claim applying for this case also because you can't take the dead person as an alive. Because policy is alive. Because he had taken the policy in dead person and
Already given, no? In that I kept it. In that not required because it's a yes. Where is the table? Page number? No, page number calculation.
Calculation is para 21, page number 21.
There are two, only one MBC. It's a case of death. Yes. What is the age? 41 years. Occupation? What is the income taken?
7,000. 7,000.
7,000. Which year is the accident? It should have been 9,500. Future prospects were considered?
25% they are considered.
Considered? What is the multiplier?
14. 9% interest has been awarded.
That we will reduce.
That. And also liability can be lordship on the count of, because 2 years a dead person carries the policy. Because 14 is the died, and we have noticed that the policy issued in the dead person after the receipt of the summons only, because they are not disclosed. And on that account, previously 2 accounts, but 1 count is already overruled by the Supreme Court. This
Your Lordship can interfere.
How many are the dependents? Huh?
2, 3, totally 3, 1/3. They are calculated, the tribunal is right in all aspect.
You said 3 dependents.
1/3.
It's coming to 15 lakh 7,888.
19.
Against 11 lakh 30,000. Now please come to the finding with regard to the 2 grounds which you have raised. Para 43.
The reason ಕೊಟ್ಟಿದ್ದಾರೆ, but I have filed the appeal. I will tell you. I know that reasons are given, but in spite of that, because on that day, Your Lordship, there is no existence of the
No, we
license.
will read it.
It is my appeal. I have to give. I know the reasons. 43, Your Lordship. Further, second respondent took a concerned contention of the policy of insurance in respect of the auto rickshaw was obtained in a company by paying a fraud and misrepresentation. Facts and incomplete long record that the owner insured died on 35/2014. Why? I don't know why, because that is the contention you have taken, and also your investigation. Dead person, you can take policy in dead persons.
If both of you want to argue, both of Mr.
Whatever it
Counsel,
may be, body or whatever, dead person is dead person. I don't know why he has
your
taken
appeal
it.
is over, your calculation is over. It's for him to
Otherwise, if fix
argue.
the against owner Lordship, then will recover from the then he knows the capacity of that. Lordship, further, Your Lordship, kindly see, poly obtained continuously. It is not 1 or 2, 2 years. And further, Your Lordship.
You have taken your premium.
Premium because unless Your Lordship, 1 minute, Your Lordship.
No, what is the disadvantage to you?
Difficulty, unless received the summons from this court, we don't know the person. We can't.
You are having the premium. You took the premium. You collected it. While paying the amount, all these things, why should?
No. But only receiving from someone that is arises. Otherwise, no. Otherwise, we will not notice it whether he is alive or not.
No prejudice to the insurance company.
Then it's all right, Your Lordship, because that is the only that second round. It is negated by the tribunal also. Your Lordship also negative. That's all. And 9% interest, Your Lordship. That has to be.
Yes.
Throughout.
Then what is the second contention with regard
Second
to?
contention are driving license, Your Lordship.
Where is that?
That is this is the para.
I think para 38.
Yes, 38. Because involving is the auto. Automatically it come under the light category.
Please come. Agreed with the award passed in MVC number 477 of 2017 dated 2nd July 2019. Both the insurance company and the claimant are before this court. The insurance company's appeal is MFA 8815 of 2019, and the claimant's appeal is MFA number 181582 of 2020. The claim petition is filed seeking compensation of an amount of rupees 40 lakhs for the death of the deceased. It's a case of the deceased, it's a case of the claimant that on 17/11/2016 at about 4 p.m., when the deceased was proceeding by riding the motorcycle, at that point of time, one auto driven by its driver in a rash and negligent manner came on the wrong side with high speed and dashed against a motorcycle, which resulted in the accident, and the deceased sustained injuries and succumbed to the same. The insurance company before the tribunal as well before this court has raised two grounds. One is the driver of the offending auto is not having a LMV non-transport. Number two, the policy is issued in the name of the dead person, and that is obtained by playing fraud, which they came to know after receiving the summons, and as such they are not liable to pay the compensation. The tribunal had held that the driver is having a driving license to drive the auto, and the non-transport, and relying on the judgment of Jagdish Kumar Sood versus Union of India, the court had negated the said contention of the insurance company. Then coming to the next contention with regard to the fake policy, the policy that is issued in the name of a dead person, the court has said that before issuing policy, the insurance company will verify the document pertaining to the vehicle and also a proposal form. They have not lodged any complaint with regard to obtaining any policy by misrepresentation. And those contentions cannot be taken, and accordingly held that the insurance company is liable to pay the compensation and awarded the compensation as per the table given below. There are so many tables here, you get confused. This one, what I start, there are 2-3 tables. This, and granted compensation of an amount of rupees 11,30,000. The claimant is before this court seeking enhancement of the compensation. The contention of the learned counsel appearing for the claimant is that court had considered 7,000 as an income. Court ought to have taken 9,500 as an income. And even under the other conventional heads also, the compensation that is awarded by the tribunal is not just and reasonable. Learned counsel appearing for the insurance company has reiterated the grounds that were taken before the trial court and submits that the insurance company is not the principle of pay and recover will apply, and they apply. Next para, having heard the counsels on either side, Pariso Mitchell non-record. The two contentions that are raised by the insurance company with regard to the light motor vehicle and the LMV license transport, non-transport, that issue is no more res integra, as Honorable Apex Court in Mukund Devgan's case has held that still the insurance company is liable to pay the compensation. Then coming to the second ground of fake driving license, the tribunal had rightly considered and passed an order, and this court is not inclined to interfere. Next, then coming to the enhancement of the compensation, this accident had occurred in the year 2017.
2016.
2016, the income has to be taken at 9,500. As the deceased is 41 years old, 25,000 for the future prospects, 25% future prospects would come to 2,375. It comes to 11,875. 3 are the dependents. 1/3 has to be deducted towards the personal expenses. 1/3 is About 3,958. If the same is deducted, his contribution to the family would be 7,960 into 12 into 14. Towards loss of dependency is entitled for an amount of rupees 13,29,888. As three or claimants towards loss of consortium, 3 into 44, 1,32,000. Funeral expenses 36,000. In the light of the law laid down in so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 15,07,888. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 11,30,000 to 15,07,888. The appeal of the insurance company is also allowed by partly allowed by reducing the rate of interest from 9 to 6, even in his contentions also that you have about the interest part. The amount in deposit shall be forthwith transferred.
Much.
Say number 13.
For the appellant, my lord, in this case, my lord, the tribunal has taken less amount towards national income, my lord.
Take this.
Accident of the year 2018, my lord. The tribunal has taken just 10,000, my lord. Per
It's a
number
case
8
of
of the
death or injury.
death case, my lord.
Yes, Mr. Mahesh.
Oh, Mahesh, sir. Sir, oh, Mahesh, sir, unmute your audio, sir.
Inform him. Afternoon.
Please, my lord.
Assault.
Sir, number 14.
Appearing for appellant, my lord, case of death.
Where
my
is, where is Pradeep?
lord.
Yes. Is it a case of death or injury?
Death, my lord.
Age?
Age about 20 years, my lord.
20 years. Unmarried?
Yes, my lord, unmarried. Bachelor.
What is he doing? What was he doing?
He is working in a private company, my lord.
Which year is the accident?
2020, my lord.
Any evidence with regard to the income? Hmm.
Tax. Fund is taken.
Then we have to take it.
Yes.
13,500.
Is taken.
And 40% future prospects?
Is adjournment.
Then what, where is
And
the
2020,
enhancement?
my lord, no income may be taken. He is a diploma, my lord. In my
When
lord.
you yourself come before the court and say that,
I agree.
then, no,
I agree. ma'am.
then,
And
then what
conventions,
other convention, how many people are there?
3 people are there, mother and father and brother, my lord.
Court has granted?
Uh,
How much it is coming to?
1,20,000 and other rates. my lord.
So now even if we calculate, where is the table?
Table, my lord.
So how much is granted? 40, 25, that is 65, 80 plus 5,
Yes, ma'am.
85. 85 is awarded.
Yes, ma'am.
You will get 88. No, 88 plus 36.
Yes,
So that we will add.
yes, ma'am.
So what is to be added to this? 14,58,000. What is this loss of future prospect?
Is bifurcated and separate head is given, my lord. 40%.
No, first time I am seeing.
Yes, sir.
Then consortium, you said 3.
3.
3 into 44. It comes to 1,32,000, 36,000 and 10,000. $17 lakhs. It's coming to something.
22 lakhs 19,200.
1 minute. Hmm. 22 lakhs 19,200.
Correct.
Please come. Agreed to the award passed in embassy number 1327 of 2020 dated 21st March 2022. Whereby the tribunal had granted compensation of an amount of rupees 21,26,200. The claimant is before this court seeking enhancement of the compensation. Land counsel appearing for the apparent claimant submits that the court had taken the income at 13,500. 13,500. It ought to have taken 14,000.
500.
It would ought to have taken 14,500. Even under the conventional heads also, the amount that is awarded by the tribunal is not, no, before that, before his contentious, extract the table at 24. The tribunal has granted the compensation, then his contention. Then counsel appearing for the insurance company submits that when this is case at, he is earning 13,500. Question of taking 14,500 as a notional income will not arise, and it is submitted that in all the counts, the amount that is awarded by the tribunal is just and reasonable. Next part. Having got the counsel signing the side, peruse the material on record. This court has perused the order, and the court had rightly taken 13,500. So under the head of loss of dependency and loss of future prospects, court had rightly considered and granted the compensation. Coming to the loss of consortium, as there are 3 dependents, 3 into 44 is 1,30,000. Funeral expenses 36,000 and 10,000 towards the legal expenses. Altogether, the claimant is entitled for 22,19,200. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 21,26,200 to 22,19,200. Yes, appeal is partly allowed.
With 6%.
Enhanced amount will carry 6%.
Much.
Yes,
Number
next.
15 adjourned, cell number 16, Sripad V. Shastri, 16.
16 is already withdrawn. In 14, Mr. P. Pradeep is permitted to file a card within 1 week from the date of, within 1 week from today. Yes.
15, 16, Sripad V. Shastri, Ashok N. Patil, RJ.
Where is he? Password? Monday. List is matter on Wednesday. Yes. At the request of learned counsel for the respondent. No representation for the petitioner.
9 and 10.
Huh?
9 and 10 date. Tuesday and Wednesday.
Then give some other day. Yes, next.
12.
Yes, yes.
17.
My lord, serial number 16, my lord. Sorry, my lord. Serial number 16. Sorry. Extremely sorry. Sorry. My lord, I filed an application for the additional document producing 53,000 rupees.
Already some calculation is done.
Yes. Only because I unable to serve the copies of these medical bills, my lord, that is stopped on that question. Now I served. My lord, main thing is, my lord, the doctors doctor appoint that 30,000 is required for future medical expenses. Like that evidence is already on record. And now he underwent surgery and about 52,000 rupees and odd. But he incurred. I produced that.
Can be granted. So, medical bills 52,000. So already calculation is over last time. Pain and suffering 40,000. Loss of amenities 10,000. Medical bills 1,17,708. Now it is another additional medical bills 52,000. Loss of future income 2,37,048. Loss of amenities no, instead of it is 30,000.
30,000.
Loss of earning during the later period 3 into 14. 14,000.
Oh, 14,000. 14,000.
14 into 3. Yes, 42,000. Oh, 42,000. Legal expenses 10,000. Then what about? Please come to the table.
It is found in page number 12.
37, pain and suffering. Oh, pain and suffering 40,000. Loss of income during the later period 14,000. Loss of amenities 30,000. Attendant charges. How many days he was in hospital?
My lord, he was 5 days, my lord.
As it is. Hmm. What is the disability according to the doctor?
That is a 25% limb, 8.3% is considered. It may not require any interference.
It is coming to 5,22,756. Disability according to the doctor is how much?
25% limb and 8.3% is considered by the trial court.
And for 8.3% disability to the limb, why are we granting loss of amenities 30,000?
My lord, the intratraumatic fracture of left femur, my lord.
We'll make it 20,000, not 30,000, because it is unless in other cases it becomes a
10,000,
problem.
my lord. The generosity of my lord is if 30%, 30,000 seems to be just and reasonable.
There is no generosity from the court. 5 lakh, it becomes 5,12,756. Yes, please come.
A loss of earning, my lord, loss of earning for the later period, how much?
42,000.
14,000 into 3, my lord.
Yes, 42,000.
Yes, yes.
Agreed with the award passed in embassy number 834 of 2020, dated 16th August 2022, whereby the tribunal had granted 3,78,756 as compensation. The claimant is before this court seeking enhancement. The tribunal had granted the compensation as per the table given below. These bills are after the.
Yes. After disposal of the case.
IA number 1 of 24 is filed for production of the additional documents stating that after the disposal of the case, he had incurred these medical expenses. The copy of the same is served on the respondent, the insurance company, and it is submitted that they have no objection to grant an amount of rupees 52,000 towards the medical expenses. In that view of the matter, the said IA number 1 of 24 is IA number 1 of 24 is ordered, and the claimant is entitled for an amount of 52,000 towards the additional medical bills. Considering his contention, and counsel for the claimant submits that the court had not granted a reasonable compensation on all the heads under the pain and suffering, and for the loss of amenities, for the loss of earning, on all counts the compensation that is awarded is not reasonable. And counsel for the insurance company submits that the court had granted a reasonable compensation. Considering the fracture injury that is sustained by the claimant, this court is granting 40,000 under the head of pain and suffering. Coming to the loss of amenities, considering the 8% disability, this court is granting 20,000. Towards medical bills, the court had already granted 1,11,708. No interference is called for. Loss of future earning also, court had reasonably granted an amount of rupees 2,37,048. No interference is called for. Under the loss of amenities, considering the disability of 8.3%, this court is granting to 20,000. Loss of earning during the later period for 3 months at 14,000, this court is granting to 42,000. As already considering the additional documents towards additional medical bills, another 52,000 is granted. Then he was in a hospital for 5 days. For the attendant charges 5,000. In the light of the law laid down in Mekala also so and so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 5,12,756. Accordingly, The appeal is partly allowed, enhancing the compensation from 3,78,756 to 5,12,756. The amount shall carry 6% interest. Yes, next.
Cell number 17.
Yes, Mr. Shastri.
My lord, in this case, my lord, the Pradeep is not yet filed the wakalat, so
He will file. He will
um,
file.
one day, at least one day, my lord, I have not gone
File.
through the record. There is 2 vehicles involved, and my claim petition is dismissed. That is why I have to go through the papers, scrutinize the paper closely. That is why a short accommodation. One day is enough.
This is matter. When is the next day? Well, basing on the matters. Yes. Yes, 18.
Date, my lord, date.
9, sir.
At the request of learned counsel for the appellant, claimant. Yes, 18.
Cell number 18. Ravishankar Shastri. For appellant.
Where is the respondent?
Lord, I appear for the respondent, my lord.
Case of death or injury?
Case of death, my lord, 20 years BE student, my lord.
20 years? BE
Engineering student, my lord, was
How much was taken?
my lord, 18,000 was taken, my lord, for the year 2020. My lord, he was a 6th semester, my lord, third year of
Yes,
engineering.
what do you say?
My lord, the
Yes, how much
My
is
lord,
income?
my lord, regarding the income, my lord, your lords may kindly appreciate. Supreme Court in my lord, Meena Pawai case, my lord, in similar case regarding engineering student, my lord, the Supreme Court has taken the income at 10,000 rupees and added 40%, my lord, awarded compensation, my lord. Around 12,000 odd it has been awarded. But in
No,
this case,
so why are you looking at only that judgment of the Supreme Court?
I'm
There are
not
other judgments
looking,
where
but
they have
my
taken
number,
80,000, 20,000, 25,000.
25.
That also, so we will take it at 20,000.
that's why, my lord, any reasonable amount, that's 20,000 is very, very reasonable. It can be taken, my lord.
What is that?
My lord, 2012 accident, my lord, engineering student, 6th semester student, my lord. This division bench of the Supreme Court has taken 25,000, my lord, per month by taking into consideration of the, my lord.
How can it be 2012, 25,000?
My lord, that is, my lord, they have considered, my lord, the payment made by the government, my lord, to that qualified students for that year. And by considering that, my lord, they have taken 25,000.
Certainly unreasonable, taking 20,000.
My lord, I leave to the Honorable Court, my lord.
20,000 will take.
Yes,
Be on the oversight, my lord. My lord, he is a merit student, my lord, who has taken the seat, my lord, in the examination. Then, my lord, his all marks card shows, my lord, he has completed with the, my lord, distinctions. And only one son, my lord, of the claimant's parents. And
25 is on the highest.
my lord, I leave to the Honorable.
But 20,000, my lord, even Supreme Court judgment, even a very recent judgment of Honorable Supreme Court in Hakim's case, that's in respect of injury case, my lord, 10,000 has been taken.
Yes.
And the tribunal has awarded, my lord,
The date of year of the accident has to be taken into consideration while interpreting such
my lord,
judgments.
one more submission, my lord, before your lordship proceeding order. My lord, your lordship may kindly see at page 13 of the judgment. My lord, loss of consortium 1,20,000 has been awarded. Further, my lord, loss of love and affection another 1,20,000 has been awarded by the tribunal.
Consider.
Therefore, I requested, my lord, to take the income on somewhat on the higher side, my lord, instead of 20,000. Otherwise, my lord, it will, my lord, I just.
But we can't. You know,
Please.
it will become a precedent in all the cases. Then we have to be reasonable. So 14,000 into 12.
Even your lords may kindly appreciate the amount granted is around 30,41,000 with interest it has been awarded. It cannot be said to be very unreasonable, my lord. Taking into consideration on a moderate scale, compensation has been awarded.
Who are the dependents?
My lord, parents and unmarried sister.
How much is awarded?
30 lakh.
41,600, my lord.
Another 2 lakh is increased.
Lordship has included medical expenses and
The
vehicle.
medical expenses are not included. How much
Medical
is-
expenses 25,000.
Let's say, please, where is the table?
Vehicle damage 25,000.
One.
Page 15, my lord, page 15.
Damage to the vehicle,
25,000. Then my lord, medical expenses 25,000.
it comes to 32 lakhs 52,000.
My lord, that
Yes.
kind permission of your lordship, my lord. As I submitted earlier, my lord, this loss of love and affection, loss of.
I have not calculated that way, Mr. Counsel. I have
Yes,
made my
sir.
own calculation.
Obliged, my lord, obliged.
Yes, please come. Agreed with the award passed in MBC number 935/2020, dated 14th November 2022, whereby the court had granted 30,41,600 as compensation. The claimant is before this court seeking enhancement of the compensation. The land counsel appearing for the claimant submits that the court ought not to have taken the income at 18,000. He's a sixth semester engineering, pursuing his engineering, and he's a merit student. He submits that the court ought to have taken at least 25,000 as his income. It is submitted that the accident had taken place in the year
2020, my lord.
has taken place in the year 2020, and the amount of the court, the 18,000 as taken by the court is on the lower side, and it needs to be enhanced. Next part. The land counsel appearing the respondent insurance company submits that in some of the cases the Supreme Court has only taken 10,000. Already in this case the court had taken 18,000 and it is already on the higher side and no enhancement is called for. He submits that court having granted 1,20,000 under the head of loss of consortium. Again under the head of loss of love and affection another 1,20,000 is granted, and for loss of estate and funeral expenses another 30,000 is granted. The amounts that are granted are already on the higher side and no enhancement is called for. Next para. I've heard the counsels on this so and so. They are considering the fact that he is an engineering student so in his sixth semester, that he is a meritorious student. This court is inclined to take the income at 20,000. Future prospects at 40% comes to 8,000, and that is 28,000. As 50% has to be deducted towards his income, towards his personal expenses. His contribution to the family would be 14,000 into 12 into 18. Under the head of loss of income is entitled for an amount of rupees. Loss of dependency is entitled, the claimants are entitled for an amount of rupees 30,24,000. Under the head of loss of consortium, 3 into 44, 1,32,000, 36,000 funeral expenses, 10,000 legal expenses. And court already granted towards damages to the vehicle 25,000, medical expenses 25,000. And in the light of the law later on, make also so and so 10,000 towards legal expenses. Altogether, the claimant is entitled for 32,52,000. Accordingly, appeal is partly allowed, enhancing the compensation from 30,41,600 to 32,52,000. The enhanced amount shall carry 6% interest. Yes.
List number 2, parted matter, sale number 1, appeal the petitioner K.V. Raghavendra Reddy, Chetan Desai,
The petitioner, my lord. Not this is-
Let it be, let it be. As far as this issue is concerned, we'll decide it. Yes. Where is the impugned order?
My lord, the impugned order, my lord, is at page number 16 of my petition, annexure A.
Operative portion?
Operative portion is in page 26, my lord.
Hmm.
The operative portion, my lord, the impugned order is
Directed to pay monthly maintenance of
25,000 and one-time litigation expenses of 20,000.
What is your income?
My lord, my income is 1,59,000. I've furnished my assistant
Expense is to the wife or to the child?
to the wife, my lord.
1,59,000.
1,59,000 per month.
What is the income of the wife?
38,000, my lord. 38,500.
Uh,
35. I apologize, man. It's 35,840.
My lord, the assets and liabilities of both the parties, my lord, have produced in annexure E and annexure F, my lord. I'm sorry, my lord, this it's annexure G and annexure H. Annexure G and H is the assets and liabilities affidavit. My lord, the marriage, my lord, was solemnized in Kolkata on 28/6, my lord, and sorry, my lord, 2/12, and further what happens, my lord?
12 of which year? Any year?
My lord, sorry, I apologize. 13/7/2017, the marriage is solemnized. I apologize, my lord. The marriage is solemnized in Kolkata, and after the solemnization of marriage, we set up our matrimonial home in Bangalore. And my lord, subsequently, after the marriage is solemnized, during the course of our marriage, I go on to suspect that she was involved in certain extramarital affairs. And my lord, her behavior also were indicative of all the suspicions that I had. And ultimately, my lord, it led to a certain instance where my suspicions grew even stronger, because I noticed that she has been receiving certain mails from a divorce matrimony website. And further, my lord, these contentions are specific contentions that I've taken up before the trial court. And my lord, the divorce petition has been filed on the grounds of cruelty and adultery, my lord. Subsequently, my lord, she files this application IA number 5, seeking maintenance of up to 1 lakh, which I contest, and my lord, the assets and liabilities I furnished before the trial court. And my lord, in my assets and liability statement, I have disclosed that my income is 1,59,000 per month, and my expenses are to the tune of 1,37,000 per month.
Oh.
My lord, I have given out, listed out the details of the liabilities and the expenses that I have on a monthly basis. In page number 116 of my petition, my lord, 116 and 117.
Let's see.
In 116, my lord, the details of the expenses towards rentals, I have expenses of up to 30,000 per month. Electricity, gas, and groceries, my lord, that's 15,000, 1,500, and 1,100. And then, my lord, I have medical expenses up to the tune of 8,200. I have an aged mother, my lord, who's dependent on me.
All this will not become, as you say, 1,30,000. It will not become. What are these expenses? Count it.
My lord, in page number 17, I have it's all in a tabular form, my lord.
That's what I'm looking at 16, and it comes to 1,37,000. Miscellaneous 29,460. Parent support 10,000.
Yes, my lord. And I have other loans and EMIs also to take care of, my lord. All of the EMIs are totaling up to 14,500 in a month.
Where are her expenditure?
My lord, her expenses she has given in her
Page number.
assets and liabilities in page number 132, in the details of liabilities of the deponent. Page number 132, my lord. She has not given a proper disclosure. Proper disclosure has not been made. It only says that there are some hand loans that she had borrowed from her friends.
No, as per the judgment of the apex court, she has to furnish what are her expenses. It is there at 128. Rent 14,000.
Yes, my lord.
Yes.
Her
household expenses 20,000.
20,000. Medical expenses of
14
2,000.
plus 20, it becomes 34, 36. 36 plus 5.
And clothing expenses of 20,000 per year. These are the expenses that she has disclosed.
Plus 14, 20, 34, 36 plus 5, 41.
Comes up to 41,000 in a month.
If it is your expenses are 41, why do you want 1 lakh? Page number? 117. No, that we will forget. We will first of all, we'll look at your expenses. You according to you require 36,000 and your salary is 35,000. Why do you require 1 lakh amount? No, that is for you to say. That is not his responsibility. No. Now, it is not basing on the husband's income, the maintenance will not be granted. You have to tell what are your expenses. You have already detailedly given the expenses at 36,000 and your income is 35,000. Why do you require 1 lakh rupees? Where are the loans? What are the loans? Monthly income 35,840. So what is the deficit is only 160 rupees. That you have to tell. My traveling expenses 5,000 already included in what I have counted now. My traveling expenses at 129. That also everything is. Please come to 128. So if you come to 128, she said 14,000, 20,000, 14 plus 20 it is 34, plus 2, 36, plus 5, 41. Was something wrong with the pagination? Show it to him, what you have filed in your papers.
Page number 120, that's my mistake, my lord. While furnishing a copy of the petition, one page has gotten missed out while I'll hand it over.
Yes. That's what I'm counting that also. This clothing is 20,000 per year. So let's take it as 2,000 per month. So 2 plus 5, 7, 7 plus 2, 9, 29, 39, plus 4. Why are you not understanding? Why did she ask for 1 lakh? No. Your main expenses cannot be 45,000 and your miscellaneous can't be 1 lakh. So now what we do is, irrespective of whatever he says, her income is, please wait. 35,840 is her income. Now, as per this, she said it is 44,000 is what she requires. So 44,000 is another 10,000. We'll grant her another 5,000, 15,000. We'll make this as 15,000.
In fact, that is the interim order that has been passed as well.
We'll make it final. I have already extra than what she asked. I'm calculating. Might be. No. You should say this is what I want. You said this is what you want is only. No. If you look at all this, what is the purpose of filing statement of assets and liabilities? To know what is your income, what are your liabilities, what are your expenditure. You said my expenditure is only this. Where is that? You have to give the details. What are the loans? Please come to that. 130. Actual amount borrowed, if any, and the amount paid to date of filing. Aditi, what is the evidence for this? There should be some supporting.
Because she was thrown away, suspecting her character. Suddenly she was thrown away from the house. She was messed up. She made a house in the home.
We'll make it 20,000.
My lord, if I may bring your lordship's attention to Annexure J. My lord, this is the company where I'm working at. It's called Sabre Technologies. For the last 4 to 5 years, my lord, the situation in my company has not been that great and anybody can be laid off at any point of time. Now, this is an imminent danger that even I am facing.
If you're laid off, then come to the court. We will see that. Please come.
My lord, let the interim order be continued as it is, my lord. That is that would be a fair disposition.
According to you. Where is the impugned order? Page number? Oh. Agreed with the award passed in 9 number 5 in MC number. Agreed with the order passed 9 number 5 in MC number 5453 of 2021 dated 28 June 2023, whereby the court had granted maintenance of an amount of rupees 25,000 to the wife and one-time litigation expenses of
My lord, if I
20,000.
may make one submission, my lord, here this impugned order, my lord, has been in effect for the last 1 year. For the last 1 year, there has been no action made by her to challenge this impugned order or to seek for an increment upon it. This honorable court, my lord, had granted a stay as well.
Those are not the grounds. Yes. Litigation expenses. The husband is before this court. Then counsel appearing for the husband submits that the wife is earning 35,848 per month, and she, all the expenses that are given by her, or it shows that it is around 44,000. And why she want 1 lakh rupees as maintenance is not known. It is submitted that claiming 1 lakh maintenance itself shows the conduct of the wife. It is submitted that the husband has filed the MC on the ground of cruelty and adultery, and when he is alleging adultery and the wife is living in a living adulterous life, in those circumstances the wife is not entitled for maintenance. He submits that in his statement of assets and liabilities, he has shown that an amount of rupees 1,30,000 is expenses, and he is left with a very meager amount, and the court without any basis had granted 25,000 as maintenance. Next, parallel counsel appearing for the respondent wife submits that the court had rightly granted maintenance of an amount of rupees 25,000, and there are no grounds to interfere. It is submitted that when the husband is earning 1,59,000 and the court had granted 25,000, the husband are not to have questioned the challenge the same. It is submitted that the wife is facing a lot of hardship. She has borrowed the loans as she was not self-sufficient, or she is not able to support herself with the income, and she has to repay the said loans. And the court had rightly considered and granted 20,000. Next, having heard the counsels on either side, there is a material on record. This court had perused the expenditure. The expenditure is coming around 44,000. Her income is 35,000 and odd. Also, no doubt, she has stated in her statement of assets and liabilities about the hand loans that she has taken from her friends. Considering all this, this court is of the view that it would be in the interest of both the parties if the amount of maintenance is reduced from 25,000 to 20,000. Accordingly, the appeal filed, the petition is partly modified. Is the order dated so and so is modified, and it is reduced from 25,000 to 20,000. Who said so? Yes. The amount of maintenance that is awarded by the court, it is from the date of the application that is filed seeking interim maintenance.
My lord, in this regard, my lord, the order says, my lord, from maintenance my lord, there is no specific mention in the impugned order stating that it has to be paid from the date of the petition.
If it is not mentioned, it should be from the date of application. Application for interim maintenance. Yes, next.
Serial number 2, Ajit Kharjan, petitioner KV Raghavendra Reddy.
Let's appear for the petition.
lords, this matter was heard by my lords day before yesterday, wherein the orders of or passed on a memo is under challenge before this honorable court.
Yes.
And also the parties. Since the class 3 has not been fulfilled by them, hence it has been not accepted by the court also on the parties. They, due to the circumstances, the changes of circumstances, the parties in the respondents are also not agreed for the same. Earlier, we got the conditional between.
Before going into any of the aspects, you have come up before the court for execution. If you are seeking execution, there should be an order. There should be an order of maintenance. Where is the order of maintenance? Take that. Give him a copy of it. Yes. As for the order passed in RPFC number, it is at the rate of 15,000 per month each. Each, how many are the petitioners? 2 in number. Huh? So 15,000 is 45,000 or 35,000? 30,000 or 45,000? Then what happened after this? There is this joint memo. Come to the joint memo now. When is no, this RPFC order is dated?
It's dated 17 December 2019.
1 minute. 17th December 2019. Then joint memo, when is it?
Joint memo, my lords, is dated
Page number?
Annexure B, page 28, 18/2/2021.
What are joint memo is dated 18?
18/2/2021.
18 to 2021. Then what is where is the basing on this joint memo? Where is the order of the court?
That is at that's the page number. Page number 40, in page number 41, my lords.
41. Case called out, petitioner 1 to 3 and respondent along with their counsels present. Therefore, the court physically.
Before the court physically.
For the court physically, joint memo is filed. At the request of both parties and their counsel, the case is referred to Lok Adalat to be held on 27/3/2021 to report final settlement. Call on 27. Where is the Lok Adalat award?
Lok Adalat, my lords, subsequently next date may kindly be seen, my lords. They take the amount which is fixed as 20 lakhs, it's done, jewelry is taken. Intentionally, they don't turn up before the Lok Adalat.
So, the fact remains is there is no award in the eye of law.
No, ma'am.
So, what then we cannot rely on this joint memo. We have to go back to the order in the RPS.
My respectful submission is it need not be referred to Lok Adalat once the joint memo is accepted and start. I may be permitted to rely upon this honorable court's decision as well as the other court's decision.
What is executable? Please tell the court.
My lords, the joint memo, once the court comes to conclusion that it is accepted and signed by the parties, then there is no necessity of the Lok Adalat to pass.
If it is not Lok Adalat,
Yes,
some court has to pass an order.
This honorable court had to pass on the terms of the joint memo once it is accepted. I may be permitted to rely upon that.
We'll consider. Pass on. Yes.
The first decision, my lords. ILR 2014 Karnataka 2051 minutes.
Paragraph?
The second head note, 11th paragraph, I may be straight away.
Yes.
That's at the bottom, entire paragraph, I may not be permitted. At last, if on the day of plaint is presented, my lords, around 10 lines above. If on the day of the plaint is presented, the parties are also present before the court, they are ready with the compromise
you
petition.
reading? It's
That's
start-
around 10 lines from the bottom, my lords.
From the bottom.
If on the day the plaint is presented, the parties are also present before the court, they are ready with the compromise, and when they are filing an application under Order 20 Rule 3, when they are admitting the terms of the compromise and execution of the terms and condition, then the court before which it is presented is the competent court to record the compromise and dispose of the suit in terms of the compromise. The question of referring the said dispute to the local adalat would not arise. If it is referred, it is a farce. If this is accepted and encouraged, both the judicial system and this alternative dispute resolution mechanism gets a bad name and would be subjected to ridicule in the eyes of the public.
That's the case, you would have questioned it at that point of time.
My lords, we have filed objections, we have informed the court, they subsequently, if my lords would.
No. When this order is passed, referring the matter to the Lok Adalat, what is the date?
They have not passed any order.
No, on 27/3/2021, when joint memo is before the court, and when the court has referred the parties to the Lok Adalat, you would have questioned this order.
Subsequently, my lords, it may be page 43 may kindly be seen of the order sheet, ink page number 43, my lords. They appear before the court. Both the advocates are present. At the request of both the counsels, the case is referred to Lok Adalat again on 14/8/21. Again, they next date.
Whatever is the date, have you questioned that?
My
Without
lords,
questioning, you can't depend upon it, you can't rely upon this and say that now the execution is not permissible in the light of the joint memo.
my lords, then every person with this conduct, my lords, they'll take the court for
And every
granted.
person with this conduct also of the petitioner will say that something is written somewhere you write something and court has to accept it. How is it? There should be a sanctity. The joint memo should be considered by the court and order should be
Yes, my
passed. When the matter is referred to the Lok Adalat, you didn't question it. Even till now, till they file their execution, you didn't question it.
My lords, that immediately the my lords, the present petition is filed and this honorable court has stayed.
Please refer to the judgments. I'm not convinced on that. Yes, then
Subsequently, the my lords, ink page number 17 is the next.
Yes.
Order. Paragraph 18, my lords. This court has held that such a practice of ink page number 18.
Yes.
27, I'm sorry. Paragraph 18. This court has held that such a practice of recording a compromise.
Same, this judgment is referred
It
to.
is recorded and subsequently at 20, my lords, the directions has been given, page 28, subclause 2, my lords.
Yes.
It is only if there is no settlement arrived at before the court and the parties request for the matter to be referred to Lok Adalat.
Yes. Next
And my lords,
judgment.
next is in page number 32, my lords. AR 2006, SC 2628.
Paragraph.
Head note, my lords, it may be relevant paragraph. Paragraph 19, my lords.
Yes.
Page number 42.
Yes.
Let us now turn to the requirement. Let us now turn to the requirement that in writing.
Yes.
In Rule 3, in this case, as noticed above, the respective statements of the plaintiff counsel and the defendant's counsel were recorded on oath by the trial court in regarding to the terms of the compromise. And those statements, after being read over and accepted to be corrected, were signed by the said counsel. If the terms of a compromise written on a paper in the form of an application or petition is considered as a compromise in writing, can it be said that the specific and categorical statements on oath recorded in writing by the court and duly read over and accepted by the to be the correct by the person making the statement and signed by him can be said to be not in the writing? We may also in this behalf refer to Section 3 of Evidence Act, which defines a document as any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording the matter. The statements the statements recorded in the court will therefore amount to compromise in writing.
Yes.
And my lords, page number 43, paragraph 10, the second paragraph, my lords.
43.
In page number 43 on the right hand side, my lords, paragraph 10, not first, second, the third, my lords. We have already referred to the definition of the term document. The term instrument used in Gurpreet Singh Supra refers to a writing of a formal nature and nothing more. And my lords, next decision is in page number 46, AR 2022, Supreme Court 2381. My lords.
Page number?
My lords, head note I may be permitted to. Legal service authorities also, compromise decree validity, Lok Adalat recording compromise between the parties in terms of the memo of compromise.
What is compromise?
Terms of the compromise decree cannot be avoided.
Unless and until it is recorded, we cannot say that it is a compromise.
Yes, my lords. In terms of the joint memo is also a recording as per the
What
evidence.
happens? You file a joint memo.
Yes, ma'am.
When the matter comes before the court, when
Yes.
a compromise has to be recorded, parties have to be present. Court will ask the parties what are the contents, what has happened. Unless and until recording all that, an order is passed, it won't amount to a paper that is filed before the court. In the
They
form
have
of a
taken the
joint
benefit, my lords. If they taken the benefit of the whatever the
That's for you
compromise
to-
that.
That's for you to, now, all these questions are not open to you in an execution petition. All these questions, all these judgments would have come to your rescue, provided the moment the matter is referred to the Lok Adalat, had you come before the court and asked the court, this is not the way, they have to, and without parting with the amount, if you have done it, then it's altogether a different aspect. We cannot stall execution proceedings based on an order, which is staring at you.
My lords, paragraph in page number 50, my lords, paragraph 18 mein kahinge.
Paragraph number 50.
Paragraph 18 in page number 50, my lords. The learned counsel for the appellant submit that the plaintiff 4 to 6 have taken advantage of the terms of the compromise by accepting a sum of 30 lakhs each as consideration for relinquishing all their rights of title and interest in the suit scheduled properties in favor of defendants, could not at the later juncture rescind from the terms of the compromise after encashing the checks issued to them.
Yes. Then the next judgment at 56.
So less, my lords, that page 55, my lords, paragraph 33.
33.
Paragraph 33 in page number 55, my lords.
Yes.
This court in Ruby Sales and so on so observed that the consent, fourth line, my lords, that the consent decree is a creature of an agreement and is liable to be set aside on any of the grounds which would invalidate an agreement. Therefore, it would follow a level of circumspection with a court of law ought to exercise while setting aside the consent of a decree based on the memo of compromise would be at least of the same degree which is to be observed while declaring an agreement as invalid.
Yes.
And there is no allegation of fraud is made before this one. Next decision is, my lords, in page number 56, my lords.
Yes.
Sir, head note 2, my lords, compromise decree, if not vitiated by the fraud, misrepresentation, misunderstanding or mistake is
Because all
binding.
these judgments will not come to your rescue because there is no compromise.
Once
decree.
they, my lords, they go ahead with the thing and take money, my lords, the conduct of the parties has to be, one more decision, I may be permitted. This decision, my lords, I will just give it, I have only one. 2014-15 SCC, my lords. Estoppel, doctrine of estoppel by election, principle of approbate and reprobate, nature of the applicability of reinstated, party accepting an order and deriving the benefit thereon, reiterated, cannot be therefore be permitted to challenge that order on any other ground. Only one paragraph I may be.
Yes, please read.
The doctrine of approbate and reprobate is only a species of estoppel. It implies only to the conduct of parties. As in the case of estoppel, it cannot operate against the provisions of the statute. It is a settled proposition of law that once an order has been passed, it is complied with, accepted by the other party and derived the benefit out of it. He cannot challenge it on any ground. This court has observed in so and so manners. May not be permitted to this one decision.
I'll pass orders in the afternoon. continuation. No mentionings now.
I'm withdrawing the serial number 5.
Take that.
List number 2, my lord.
Only withdrawals, only are permitted at 1:30.
Serial number 21, my lord. Matter may be referred to Lok Adalat, my lord.
Why every matter for the adjournment it will be referred to the Lok Adalat?
No, my lord, last time also
We will
discussion.
see. We'll see.
Serial number 6, my lord.
This is
Serial number
WP
6.
number 8120 of 25. Memo is filed seeking to withdraw the petition. As the matter before the trial court has reached the final arguments, memo is taken on record, dismissed as withdrawn. No mentioning for.
Serial number 6, my lord. Memo of withdrawal will file, my lord.
It has to be called. Morning you mentioned, I think.
Yes,
It has to be called. Because you have to look at the memo on what. That's why I asked you. You have a copy of it, I'll record that.
But I have a copy, but the copy has not been signed by the party because I already filed it in the
Then
March
wait,
itself, my
wait.
lord.
ಯಾವ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾ 8120 ಅಲ್ಲ dismissed as withdrawn ಅಲ್ವೇನಾ ಸರ್ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ ಇಷ್ಟು ಬೇಗ ಎಲ್ಲ ಮಾಡ್ತಾರೆ ಸರ್ ಹೇಳಿ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಮಧ್ಯಾಹ್ನ ಬಂದಾಗ ಕೇಳಿ ಇದು ಮೆಮೊ ಆಮೇಲೆ ಬರ್ತ್ ಕಳ್ಸೋಣ ಹೇಳಿ ಸರ್ ಮೆಮೊ ಫಾರ್ ವಿಡ್ರಾಯಲ್ ಇದೆ ಫಸ್ಟ್ 2:30 ಬಂದಾಗ ಹೇಳ್ಬಿಡಿ ಮೆಮೊ ಫಾರ್ ವಿಡ್ರಾಯಲ್ ಇದ್ರೆ ಯಾಕಂದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಡಿಸ್ಕಷನ್
ಅದೇ ಅದಕ್ಕೆ ಒಂದು ಸ್ವಲ್ಪ
ಸರ್ ಹೇಳಿ ಬೆಳಗ್ಗೆ ಅದೊಂದು WP ನಂಬರ್ ಕೊಟ್ಟಿದೆ ವೆರಿಫೈ ಮಾಡ್ಕೊಂಡ್ರಲ್ಲ ಅವರು ಪಿ ಎಸ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಇವಳಿಗೆ ನಿಮ್ಮ ಟೈಪಿಸ್ಟ್ಗೆ ಅದು ಆಡಿಯೋ ಇದು ಮಾಡಕ್ ಹೇಳಿದ್ರು ಮೇಡಮ್.
Continue.
Yes. Number 2, serial number 2.
CPC is there.
CPC.
Okay, there's order 23 rule. There is impugned order. Impugned order page number.
It's annexure A, page 14. The operative portion is at in page number 70.
Operative portion is at page 25. No?
17 minutes. Annexure A.
Starts at 17 and the operative portion is at 25.
It is at
25.
25.
Please come.
One submission is not my respectful submission is that once the learned judge has accepted the joint memo on the top of.
No, I understood your contentions.
Yes, Manoj.
I'll record all
To be
content.
granted a liberty also to approach the trial court for.
The agreed with the order dated 30/10/2023, whereby the court has accepted the memo of calculation filed by the wife after adjusting payment of rupees 20 lakhs made by the husband. There is remaining amount of rupees 7,32,000 towards arrears of maintenance claimed in the petition. Hence, the husband is directed to pay the same. For balance payment and or steps, the matter is posted to 21/11/2023. For the sake of convenience, the parties are referred to as husband and wife. The wife had filed C miscellaneous number 313 of 2009, and in that came to be allowed by order dated 10th January 2013, whereby the husband is directed to pay monthly maintenance of 15,000 to petitioner, to the petitioner number 2 therein from the date of order. Petition number 2 is who? Petitioner number 2 is the son. Order was passed whereby the husband was directed to pay an amount of rupees 15,000 to the son and 15,000 to the daughter, and also no 15,000 each to all the 3 petitioners, and 25,000. The court has passed an order whereby 15,000 each is granted to the wife and to the 2 children, and also 25,000 towards the litigation expenses. Thereafter, the husband had filed RPFC. Both of you filed. There are 2 RPFCs.
Yes.
Both the wife and husband had preferred a revision against that order. That is RPFC number 31 of 2013 and RPFC number 50 of 2013. And by order dated 17 December 2019, the RPFC number 31 of 2013, that is filed by the husband, is dismissed with cause and RPFC number 50 of 2013 filed by the wife is partly allowed with cause and the order of the family court is modified and petitioner and the wife and 2 children are awarded maintenance at the rate of rupees 15,000 per month each. Where is the modification then? Same order.
No, from the date of the order.
Per month each from the date of filing of the petition. NC miscellaneous number 313 of 2009 till the periods stated in the impugned order. It is next. It is submitted by the learned counsel appearing for the husband that thereafter the parties have entered into a compromise and they have signed a joint memo that is dated
18 to 2021.
18 to 2021 and where is that proceedings you are referring to?
Well, it's a joint memo.
No, not joint memo. There are the court proceedings before the court.
Well, it's page number 41.
41. On 18 to 2021, it is observed by the court that the petitions 1 to 3 and respondent along with their counsel present before the court physically, joint memo is filed. At the request of both the parties and their counsel, the case is referred to Lok Adalat to be held on 27/3/2021 to report final settlement. Call on 27/3/2021 before the Lok Adalat. Then the proceedings stated 27/3/2021 discloses that the respondent counsel filed a memo, the petitioner and counsel absent, that is the wife and the children and their counsel, matter not settled, send back the file to the court. For objections to memo, if any, call on 26/5/2021. Then the proceedings of 26/5/2021, after that, again an order is passed on, what is this order date?
My lords, this is
14/8/2020.
Not 14/8, that is call on 14/8.
14/7/21, my lords, on the left hand.
15/7/21, as per the docket order, it records that both advocates are present at the request of both counsels. Case is referred to Lok Adalat to be held on 14/8/2021. Call on 14/8/2021. Then the proceedings of 14/8/2021 shows that before Lok Adalat, the petitioner and the petitioner's counsel absent, respondent and respondent's counsel present, matter not settled, send back the case filed to the court. Call on 7/9/2021. It is submitted that by the learned counsel that as per the joint memo, they have already given back the jewelry and paid
20 lakhs.
Paid an amount of rupees 20 lakhs. Now the joint memo is acted upon. Now they have moved the court by filing this execution and a calculation.
He just filed a memo before the same court.
They filed the memo before the court saying that there are certain arrears of maintenance, and by order impugned, the court had directed that the husband has to pay an amount of rupees 7,32,000.
7,32,000. Correct.
The court in the order has observed, the learned counsel submits that when the compromise memo is acted upon by the parties, question of this recovery, this order and the order on the memo are not sustainable. It is submitted that when the joint memo is filed before the court and the parties have agreed upon and entered into a joint memo, and when the same is placed before the court ought not to have relegated the parties to the Lok Adalat. Instead, court ought to have recorded the settlement. It is submitted that the procedure that is adopted by the court in sending the parties to the Lok Adalat is contrary to the settled law. He had relied upon the judgment of the he has relied upon the judgment in case of Srimati Akkubai versus Sri Venkatrao and others, reported in ILR 2014 Karnataka, page number 2051, extract paragraph number 11, relied on paragraph number 11. He has relied on another judgment in arising out of writ petition number 103766 of 2018 between Srimati Renuka and Sri Ramanand and others. He relied on paragraph number 18 and 20. Next, he relied on Pushpa Devi Bhagat versus Rajinder Singh and others, reported in AR 2006 Supreme Court 2628, paragraph 19. Then, K. Srinivasappa and others versus M. Mallamma and others, reported in AR 2022 Supreme Court 2381, para 16 and 33. Then, in case of Bairam Pestonji Gariwala versus Union Bank of India and others, reported in 1992 1 SCC, page 31. Which paragraph in this?
The second head note, Manoj.
Just the head note.
Yeah. Paragraph
note.
11, my kind.
Relying on these judgments, then counsel submits that.
That's 2014 one judgment. That's enough.
Where is it? It's held on State of Punjab and others versus Danjit Singh Sadhu. Paragraph number?
Well, it's last paragraph.
Paragraph 22, 23, 24, marked portion is there till 25. Relying on all these judgments, then counsel submits that in fact there is a valid settlement between the parties, and that settlement cannot be a question unless on the ground of fraud and coercion. In this case, none of those grounds are taken, and the said joint memo is binding upon the parties, and the court, as the court failed to record the same, this court has to take a note of it, and the compromise needs to be recorded. It is submitted that the parties who have acted upon the joint memo and having had the benefit of the said memo, no, they cannot go back on the same. That is impermissible. Once the joint memo is held to be correct, now the question of executing an order that is passed in RPFC would not arise, as the joint memo is subsequent to the order that is passed in the RPFC. Anything else?
Well, it's once the learned judges sign, my lords, it is deemed to have been expected.
That's in the proceeding. Earlier paragraphs I have recorded.
Yes.
My contention is class B has not been complied by under the joint memo, my lordship.
The argument which you are now advancing,
Please,
it will support his
please,
case.
please, my lordship.
The learned counsel appearing to the respondent wife submits that the compromise is not recorded by any court. There is no a compromise decree or there is no Lok Adalat award unless and until there is an award or a decree. The husband cannot rely upon the said joint memo. It is submitted that the court had rightly considered as per the order passed in the RPFC what are the arrears and by order impugned the court had directed.
One submission. There was no mention of RPFC before that honorable court, my lords. Only the reasoning that has been given is since it has not been accepted, maybe exact relevant paragraph I may be permitted.
No, if you have any objections, you can file.
No,
Do you have any
because the
objections?
RPFC was never brought into the picture there before that honorable court. It only says the court has not passed any order and the parties are not heard. And in fact, the matter is
That they have said it or not, the amount is as per the RPFC. Otherwise, they can't. There cannot be any calculation.
Fine.
What it is. Rightly considered and rightly held that the amount, the husband is liable to pay the amount, and there are no grounds to interfere. Next para. Having heard the counsels on either side, peruse the material on record. This court has heard the argument of the counsel by the petitioner and also perused all the judgments that are placed before the court. There is no dispute with regard to the proposition that is laid down by this court and Honorable Apex Court. First of all, questioning of a compromise decree or an award is only available under the specified grounds like fraud, coercion, undue influence. According to the learned counsel, it is nobody's case that there is a fraud or coercion, and in that case, the compromise decree cannot be questioned. Compromise decree oblique award. Here, the case is there is no decree of compromise or award which is known to law. If such a decree or an award is passed as per law, then all the judgments that are relied on by the counsel for the petitioner can be considered. The petitioner is relying on a judgment in ILR 2014 Karnataka, that is in case of Srimati Akkubai, which was later considered in WP number 103766 of 2018. There, the learned judge was discussing about the scope, about the manner in which the case was decided. When the parties have filed a compromise memo, court has observed that they should the court it is the duty of the court to record the compromise, but they shouldn't be relegated to the Lok Adalat. Petitioner had an option to come before this court when the parties have filed the joint memo and the court has asked them to go before the Lok Adalat. At that point of time, the petitioner could have come before the court, and in those circumstances, the judgments that are relied on by the petitioner would come to his rescue. But the petitioner has not done anything, and he has, after the matter is referred to the Lok Adalat, when the respondent wife has not turned up, and the joint memo was left at that point of time. In those circumstances, it cannot be argued and it cannot be accepted by this court that it is a compromise decree, and the parties cannot go behind the same. As of now, the order which is acceptable under law is the order that is passed by the passed in the revision in RPFC. If, according to the petitioner, there is a joint memo and the party is going, part of it is already is enforced, or is part of the obligation, he has already paid the amounts and under the law, whatever is the remedy available to the petitioner, it is for him to pursue, subject to the law of limitation. But basing on that joint memo, this court cannot interfere with the order impugned before this court. The order impugned before this court is basing on the amounts that were granted, what were the arrears from the petitioner. It is not the petitioner's case that, as per the order passed in RPFC, he is not liable to pay a particular amount, even in those circumstances also. Also, this court cannot interfere with the order impugned. Accordingly, this court is passing the following order. The order dated so and so requires no interference. Accordingly, the writ petition is dismissed. However, it is left open to the petitioner to question the order, passed by the Lok Adalat, passed by the court, referring the parties to the Lok Adalat if the law permits and if it is within the limitation.
That's until the consideration, Malas, the interim order granted by this honorable court, let it be. I'll make a necessary application before the trial court.
Till number 3, Rajeshwara PN for petitioner, CS Ramachandra Reddy.
Respondent number 1 and 2 in this matter.
Appear for the petition. Husband's petition was challenging the order of maintenance. Husband's petition was
Where is the order?
Order is at Annexure A, page number 16. The operative portion is at page number 24 minutes. Shall I read paragraph number?
Wife is for wife 30,000 and for daughter
For son, man.
20,000. 50,000 is granted.
Yes, ma'am.
What is your income?
Well, in the order, I have not filed my assets and liabilities, when the order was passed. After the order is passed, I have filed my assets and liabilities. According to me, I have shown that I earn 45,000 per month. Even according to the wife,
You not find your statement of assets and liability.
My father was not well, so I could not file it within time. It was taken as not filed and the orders are passed. Subsequent
submission to that.
I'll make 2 minutes. Wife is earning, even according to her assets and liabilities, she is earning 35,000 per month. She is an assistant professor in a reputed Jain university. The son is aged about 4 years. The impugned order is passed on the ground that wife is residing separately, but wife and the children are residing with the husband. And all her daily needs are being taken care of by the husband. She has filed assets and liabilities showing the address as the husband's home address. Even before this honorable court, she has filed IA for vacating where the address is shown husband's home address. And she does not dispute the fact that she is residing with the husband. And she is capable of maintaining herself 35,000. This honorable court, after considering the same, has passed an interim order directing the petitioner to pay 10,000 to the son. He is studying in LKG. The time complying have been paying 10,000 to the respondent. My only submission, when the order was passed, the assets and liabilities were not on record. Now that it is on record, Lords may direct the trial court to reconsider the matter.
The Lordships can turn to page number 40 of the petition. This is the assets and liabilities of the petition. This is the assets and liabilities which I have filed before the trial court. In that, Your Lordship, nowhere have I stated or nowhere have I requested that there needs to be maintenance for my rent, Your Lordship. I have admitted that I am staying with him. I have admitted that I am staying in his house, Your Lordship. But if Your Lordship recollect, this is a matter wherein the petitioner is the CEO of one company, and he is claiming that he's only earning a salary of 45,000, Your Lordship. So Lordship had directed them to give the bank statements of his company as well as the shareholders agreement of his company, and they have submitted that on the previous occasion. Lordship.
What it discloses?
Lordship,
Dear memo, Your Lordship, if Your Lordships can turn to page number,
When is it filed?
29/7/25.
Lordships can turn to page number 7 of the memo filed by the petitioner, Your Lordship. Lordships can see the account number at the top and right side column, Your Lordship.
Memo producing the document.
Please, Your Lordship. Page number 7 of that memo, Your Lordship.
There are no page numbers to this.
There is page number.
There, it is marked in the ink pen.
Cash deposit.
Page number 7 of the.
No page numbers to this.
Oh, really? 29/7.
How many papers it contain?
That is in compliance with the order we have filed, madam. This is another
compliance
memo.
memo, Your
madam.
Lordship.
That is a compliance
memo.
memo. madam.
There is another memo filed on 29/7.
Recent memo. madam.
For producing the documents.
Is filed in the open court.
What date it, sir?
29/7.
Huh?
28 filed by the petitioner.
Good. Quarterly good. Huh.
There are nothing, no papers here.
One more.
Yes.
Keep it. Lordships can turn to page number 7, Your Lordship, of that memo. So the documents which they have produced account statements of 2 accounts, Your Lordship. And one account number is bearing 5020052202868, Your Lordship. The last 3 numbers of this account number may be noted. 868. And the other one is bearing the last 3 digits are 408, Your Lordship. These are the account statements which they have produced, which is not complete, Your Lordship. They only produced it up till 31/3/2025. If Your Lordships can come to page number 117 of the petition. No, 117 of the petition, Your Lordship.
Ultimately, what is the balance? What is the balance of this account?
So balance is
Nil balance.
even in this, Your Lordship, there's credits of rupees 2 lakhs, rupees 2 lakhs, rupees 3.5 lakhs, which are the grants which comes to his company, Your Lordship. And he is the CEO of this company. So his allegation or his
Then I'll set
contention.
aside this order and whatever the interim order is, because I can't go into all these things and I can't
Please, Your
stipulate.
Lordship, I'm only trying to establish the malified.
That's what
on
what
their
I'm
part,
saying
because
is,
they are claiming that he is only earning 45,000, Your Lordship. And they're also claiming that he only has 2 accounts from the company. But if Your Lordships can turn to page number 117 of the petition, it shows that the salaries which have been credited to his account, this is his personal bank statement.
What we do is, whatever is the interim order, let it be enforced till further orders are passed by the court. I'll set aside this.
What has happened is, Your Lordship, the respondent number 2 is the kid. He suffers from a genetic disorder, Your Lordship.
He suffers
from a genetic disorder.
Then let the father
sir,
take care of the
I
entire medical
seriously
expenses.
dispute this,
Even apart
Manoj.
from that, Your Lordship, I may be permitted to file my memo.
I will take care of the child, Manoj. I have no difficulty in taking care of the child, Manoj.
His school fee is only 26,000 per month, Your Lordship. And I am taking care of it. What
26,000
are
per
contentions
month,
they are
which
saying now that I am residing with the petitioner, Your Lordship. That is true. That is not in
Will
dispute.
say, no
That is not in dispute, Your
no
Lordship.
maintenance to the mother. Let father take care of educational and the medical expense,
saying
complete
now-
medical expenses.
No, Lordship, they are saying
Please.
that they are deciding together, which is not in dispute, Your Lordship. But what happens in just merely because they are staying in a shared household, that does not mean that all the facilities are being provided to her, Your Lordship. They are not giving her any even groceries. If she goes to cook, they are saying you're not allowed to cook, Your Lordship. This is the instructions that she even yesterday, Your Lordship. These
So what to do?
instructions-
What the court can do?
Lordship, the interim order which was passed by the trial court, that may be upheld, Your Lordship. Because, Your Lordship, 50,000 is what you're seeking.
There should be some basis for that. How the court has granted 50,000?
Lordship, because
No,
the
if a
respondent
person is so and so, that doesn't mean that the court cannot determine his income.
Please,
There
Lordship,
should be
we are
something.
not stating on that basis. I'm only contending
I'll
that-
pass an order now that all the medical educational expenses of the child shall be borne by the father.
Please.
Lordship, but even then, Your Lordship, until now, the mother or the respondent number 1 has been
That
paying
will
the
be
fee.
considered by the court.
She's taking hand loans, she's taking loans from everyone, and she's paying, Lordship. Your Lordships can turn to page number 4 of 2 of the memo.
50,000,
Lordship,
the court will not pass such an order.
I've been paying 20,000
Why the court has passed this order, we have to We have to ask the court. On what basis
Lordship,
50,000
even
is
apart
granted?
from that, Your Lordship, the contention which they are saying that they have not filed the assets and liabilities before the trial court. If Your Lordships can see, Your Lordship, on 21/2/2024, they have been placed ex parte. The order is passed on 21/8/2024, Your Lordships. Numerous opportunities are granted to them for almost a period of 6 months. The trial court has carefully considered all these aspects, Your Lordship. They were
What
given
considered? What carefully considered?
21/2/2024, they were placed ex parte.
That is, they have not filed the statement of assets and liabilities. That's it.
Yes, Your Lordship. But when they were given an opportunity that when they are residing in the same house, when they are quite aware of the fact that.
Then if
maintenance
you argue
petition-
like this, then the only option is I'll set aside this order and send it back and let it determine. Or else if you're ready, I will say you pay this amount. These are only options.
So some maintenance may be given into the wife also. Your
What
Lordship.
was interim order?
10,000.
Let it continue, and apart from that, take care of other expenses.
Other expenses including the education.
That's what I said, educational and medical expenses. Where is improved order? Agreed with the order.
Page number
passed in
16.
criminal miscellaneous number, IA number, on an interim application in criminal miscellaneous number 1/7 of 2023, dated 21st August 2024, whereby the court had granted 30,000 maintenance to the mother, to the wife, and 20,000 maintenance to the child. The husband is before this court. Then counsel appearing for the husband submits that the monthly income of the husband is 45,000. As his father is not feeling well, he could not file his statement of assets and liabilities, and the wife is earning an amount of rupees 35,000 per month, and 50,000 maintenance that is awarded by the court is on the higher side. It is submitted that if the matter is remanded, should get an opportunity, and they will file their statement of assets and liabilities. When this court has asked them to file the bank statement pertaining to his personal account as well as a company account, the bank statement is placed before, then counsel appearing for the respondent submits that bank statement is incomplete, and apart from the 2 accounts, he's having another 2 accounts.
Numerous accounts. Your Lordship, more than
He's
3
having numerous accounts, and they are not placed before the court. This court cannot go into all these issues at this stage. Next, it is submitted that the boy is suffering with some medical issues, and it really requires constant treatment. For that also, the wife had to spend the money, also the educational expenses. Then counsel appearing for the father submits that father is always ready to take care of the medical and educational expenses of the child, and in fact the child is staying, both of them are staying in the staying together in the same house. The next part, having heard the counsel on either side, when was the material on record? Generally, when an opportunity is given to the husband to file the statement of assets and liabilities, he has chosen not to file. Now he has come before this court, questioning that order. This has become a routine practice for all the parties to not to file when an opportunity is given, they will not file the statement and will come to this court after the order is passed. Now, even for this court to decide, the learned counsel appearing for the respondent, submitting that all the statements are not, all the bank accounts are not placed before the court. Considering all this and balancing the interest of both the parties, this court is passing the following order. The order dated so and so, passed by so and so, is set aside, and the matter is remanded back to the court. Pending consideration of the application, the husband shall pay the medical, educational, shall take care of the medical, educational expenditure of the child. Number 3, he shall continue to pay 10,000 per month as maintenance to the child. Next, both of them shall file, the husband shall file the statement of assets and liabilities, which shall include all the bank accounts standing in the name of the personal name of the petitioner, and also the company within 15 days from the date of receipt of the copy of the order. Thereafter, within 1 month, or within 2 months from thereafter, the court shall decide the application accordingly disposed of.
So the interim maintenance of.
Great.
Able to respond, maybe
Hmm?
clarify that from the date of the application.
From the date of?
From the date of the application.
From the date of interim order, we have been paying, my lords. Well, the order is set aside.
Now he will be paying 10,000 till the application is decided, that is 2 months. Yes.
Any directions can be issued for consideration of the application within a date to the trial court, Your Lordship.
I think I'm so loud, you can hear me. I said it is, the time frame is already fixed.
Case number 4, Ravindranath A, for petitioner.
What is this admitting the document?
Lordship, last time your Lordship asked me to produce that execution petition 129
Uh,
that I have produced.
uh. What is order impugned?
Impugned order is,
Hmm.
I have filed, I am for the petitioner wife. Husband filed MC petition.
Hmm?
Husband filed MC petition for divorce. I filed an application under section 24. The Honorable Court granted me 6,000 rupees per month. He did not pay at all. He did not come to the court at all, in spite of several NBWs. Ultimately, I was forced to file an execution petition. That execution petition, Lordship, your Lordship last time asked me to produce that particular execution petition. My Lord, during the pendency of this execution petition, I filed one independent petition under section 125 of the Criminal Procedure Code. That is a separate independent petition. That is for permanent alimony and that 125.
125, how can there be a permanent alimony?
No, I wanted, I requested, I filed the petition. No, it is not a permanent alimony. For returning the prayer column, your Lordship will kindly see. At page number 26. (28), my lord. Criminal petition number 407. I tried for independent maintenance along with other demands. At page number 35, your Lordship will kindly see the prayer column. Her father is working in a small Kalyana Mandapa, earning some 20,000
Under
rupees.
125 CRPC, to pay rupees 40,000 as maintenance.
Yes.
6,000 rent, 60,000 one-time payment.
He is a
10 lakh
businessman.
marriage expenses.
He is a businessman working, not working at all. He is having 3-4 shops in the prime locality. Anyway, in any case,
Anyway,
of course, it
yes.
is left to the court of the.
Yes.
It is left to the, court.
Then where is the execution petition?
No, this execution petition is for executing the order passed by the under section 20.
No, you said you have filed it as per
I have
the
filed
order
it.
of
I
the
have filed
court.
it. I have, at the instance of your Lordship.
No, come to the impugned order. Page number.
Page number. It is particular.
No, impugned order.
Interim order. I will tell. Page number 40, my lord. 41. 41. Criminal petition number 417 of 21. Case called out. Both parties present. Both counsels present. The petitioner has filed this petition under section 125 of Criminal Procedure Code to execute the order. No, it is not to execute the order.
This order is passed on 21/12/2021. Why is it questioned now?
My lord, she is a very, very poor lady. She did not get even one paise maintenance. She could come to me only after getting some amount through the garnish order. I have produced that particular document also under section Annex E 42. I have produced, after a lot of inquiries, I was able to get the clues that he has deposited all the monies here. Some 45 crores, 45 lakhs he has deposited here. He sold all his shops. He did not pay a single price to the lady, my lord, to his wife.
Where is the affidavit to say that why did you come to the court after for 5 years?
I have in the main petition itself, I have narrated my lord.
Where is that?
Interim relief, grounds for interim relief. At page number 5 of the main petition, my lord.
After that, what happened to the execution?
My lord.
What happened to the execution?
Execution was closed.
Petition.
Execution was closed after the bank paid the amounts.
So now after all that, after MC execution and all is over, now you want this.
My lord.
In MC, interim maintenance is granted.
He
is paying it.
It was dismissed. He did not prosecute it.
What is dismissed?
He sought some time.
Execution is filed by you.
No, execution, of course, it was accomplished. It was closed after fulfilling the directions.
After that, you want to revive this petition on 25.
No. It is an independent petition. Criminal.
Correct.
My lord.
Court has dismissed
Yes,
long back.
during this 24.
You are pursuing your EP,
No,
your
it was
execution proceedings.
the
You will recover the amount, but to come to this court, you are taking 5 years.
No, not 5 years.
This
Not
5 years.
Not 5
Almost.
Years. No, my lord. About 3 years, maybe. That's what I have explained to it. The problem
No, never it explained. Where it is explained?
I have explained everything in this
Please read.
grounds that the Garnishee Bank appeared before the Honorable Court at page number 5, paragraph 15, and submitted a statement whereunder the respondent had as much as rupees 46 lakhs as accumulated balance. A copy of the bank statement dated 9/4/25. After 9/4/25, when I produced this particular document, the court was able to direct the bank to pay me the.
Correct. What is the connection
Yes.
between
So,
that and this?
only after receiving that amount, she has come to the.
Please come.
Your Lordship will
You know, already-
kindly
Huh?
take sympathy to her because
What
she's a
sympathy?
very, very poor lady. Very, very poor lady. 6,000 rupees after all, my lord. He has not paid a single pie.
It will not, no.
No, my humble submission to your Lordship is
File, will grant you liberty
No,
to
I-
whatever petition you want to file.
appeal is not maintainable.
Hmm?
Appeal cannot be made. This is only, I have got a right only under the writ petition because the learned district judge has passed, the family judge has passed an order stating that the IF, that the order passed by MC petition number so and so, which is not maintainable.
Passed on.
No, what I am
Passed on
trying
21.
to convince your Lordship is
Agreed
the very
to orders
order is
passed.
bad. That is why
The
it has to be restored back.
Number 417 of 2021, whereby the court has dismissed the petition that is filed under 125 CRPC on the ground that the said petition is filed under section 125 CRPC to execute the orders passed in MC number 3494 of 2018 dated 23/2020, which is not maintainable. And the court has observed that the petition, but the wife has already filed execution number 129 of 2021 to execute the order passed by the court on I number 3 in MC number 3494 of 2018 dated.
May I interfere, your Lordship? I am my humble submission to you. It is a 125 is a separate and independent position. It cannot
That I
be.
will record, I will record, I understood that submission. Hence, the petition is dismissed and directed to return the documents to the petitioner as per the rules. That order dated 21/12/2021 is questioned before this court by filing the present writ petition on 2/6/2025. Learned Counsel submits that the petition that is filed under 125 CRPC and the execution petition that is filed are not one and the same. Now, in the execution petition that is filed, the amount is recovered, and the amount is recovered, and as she is not financially sound, she could not come before the court. By filing this revision, further, by filing this petition, and further it is submitted that she is in dire need of the amounts. An application under 125 CRPC can be filed whenever there is a requirement or when the wife is in need of the money against the husband. As far as this order dated 21/12/2021 is concerned, court has only, as the court has passed an order saying that this is an execution petition seeking execution of the order passed in MC number 3494 of 2018. That order, after almost 4 years, is questioned before this court. This court is not inclined to go
This
into
particular date,
go to the
Lordship will kindly excuse me. 9/1/25 only she got it amount. This 9/1/25
on
at page
21/12/2021.
number 5.
At any stretch, this court is not inclined to interfere with this petition.
9/1/25 only.
Passed by the court. If the wife is in need of money, she can always file an application under 125 CRPC, and it's for the court to entertain the same accordingly disposed of. Yes, next.
Serial number 5 disposed. Serial number 6 for order. Serial number 6. Move for withdrawal.
Take that.
Hearing for the petition numbers.
A memo is filed seeking to withdraw the writ petition. It is stated that the dispute between the parties is settled in MC number 1832 of 2016 before the mediation center. And a decree of divorce was granted on 2/2/2024. Hence, the petitioner wants to withdraw the petition. Memo is taken on record and dismissed as withdrawn. Next 7.
Cell number 7.
Give the letter. This court by order dated 16/6/2025 has directed the, where is that order? This court by order dated 16th June 2025 has directed the family court where is this? There's nothing. This is not the order.
In the letter stated that
This is 16/6. No, there is a order to dispose of the matter. Where is it? This court by order dated 16th June 2025 dispose of the petition and directed the court to dispose of the matter within 2 months from the receipt of the copy of the order. So the letter is addressed to the third additional principal judge, family court, stating that they have filed an SLP this is questioned before the Honorable Apex Court, and the mediation efforts are being made, and the court has not received any stay order. Hence, the learned judge has requested for 1 month time for disposal. Next para. When there is no, when the Honorable Apex Court has not granted stay, what was the reason for the court to wait for the order, stay orders? When the parties, it's a duty of the parties to place an order of stay, if any, by the Honorable Apex Court. And the court cannot simply wait for the order. And again, this court feels that there is no basis for the family court to seek extension of time. On the face of it, the delay, there is no reasonable, this court do not find any reasons for the delay. Finally, 1 month time is granted, and the order, the petition has to be disposed of, and no further time will be granted. This number is right now. Here, tell me in chamber. Yes. Next. Next matter.
Cell number 8.
Respondent in this matter.
was an interim order directing the petitioner to pay the amount to the respondent.
Non-filing of memo of calculation by counsel for respondent.
On the last date, they have said that they have deposited the DD. The DD is still lying in the file that has not been encashed. So now the validity of the DD is also expired. Let them pay the amount to the respondent.
We'll hear the matter and pass orders because you are not coming up. There is a direction. When was the direction to you?
On 8/4/2020.
Then why you did not?
Lordship, 2 installments were to be paid, my lord.
Looking at the memo filed with the learned counsel for the petitioner, the learned counsel the respondent shall file the memo of calculation.
Yes.
This is matter on 3-9. Where is your calculation?
No, I have also filed, but now
Looking at their memo, I asked you to file.
my submission is that what amount they have deposited, that DD is there in the file, your lordship may kindly see. That DD has not been encashed.
Where is the DD?
My lordship, I had deposited on
That
3rd
is in
May
the file of this honorable.
in the
court.
name of this hon.
There is a direction it should be deposited before
My
the
lordship,
court.
the
Why
issue-
not to the file?
My lordship, there were 2 installments to be paid, my lord. When the interim order was passed, we had requested for bank account. They didn't give it in time, so we deposited first installment before the court. The remaining directly we have deposited, and that same they have acknowledged the same. Because of the interim order, we had deposited that.
Anyhow, that
In
order will
couplets.
pass, argue on the merits of it.
Lordship, hearing seniors should come, my lord. For
Yes. This is matter on 26th of September.
please, my lord. Interim order may be extended.
Till number 9. Till number 9.
I appear for the petitioner wife. The writ petition arises from a petition of divorce filed by the wife.
What are the office objections?
Yes, my lord. The first one, if my lord would kindly look into the impugned order at page number 18. Along with the petition, we had filed IA number 2 seeking maintenance for the wife, IA number 3 seeking maintenance for the child who's 4 years old now. And subsequently, after the child was admitted to school, we filed IA number 9 for payment of.
IAs cannot be questioned by one writ petition.
Please.
It has to be separated.
Yes, I have filed a separate IA for maintenance of wife, a separate writ petition. Yes,
A separate writ petition for every IA.
my lord, the IA number, this present writ petition, I'm only clubbing the IAs for payment of maintenance for the child and for payment of school fees. A common order has been passed.
The difficulty for the court is, in several cases, in one writ petition, you are questioning 2-3 IAs. And it's but difficult for the court, even under the civil rules of practice also, it's an independent application, independent order. It has to be questioned by way of an independent writ petition, not that the rules that are for the general miscellaneous, that one court fees, you pay the court fees and all common orders that we cannot entertain.
My lord, because the order is a common order that is passed and the issues and facts that arise, I've not clubbed the wife's maintenance application with this petition. I've filed a separate writ petition for that.
It's a matter of
My lord, if
procedure.
I could just make a
We
submission.
will not give too much of discretion to the section to decide which to be allowed, which not to be allowed.
My lord, the writ proceedings rules also does
Writ
not.
proceedings rules, what you are questioning in a general miscellaneous GM's matters, and then this matters arising out of the family court proceedings cannot be one and the same. That's what they have issued a separate circular now, that it cannot be, it is not maintainable like that.
I have a judgment. I'm not aware of the circular though. But I do have a judgment which says that since the writ proceeding
under 226,
if I could just rely on it, it says that there is no bar against a single petitioner filing.
That is there in writ petitions you file, but not.
In paragraph 10, page 505. Para 10.
That's what I'm saying. That writ petition under 226. No, these are under 227. Though here in Karnataka it is called as writ petition. In other states it's called as CRP, a civil revision petition. For example, if an order is passed by the civil court where injunction is granted, some other order, it will have an order, an executable decree will also be there. How can there be one petition against 2 orders just because you are filing the court fees? It is not. This order will not apply I've already, because seeing all this, we have all discussed about it, and it has to be different repetitions against different IAs. I'll tell you the instances where 2-3 are clubbed. Ultimately, what is to be done to the repetition, court is not able to understand. 2 IAs to be dismissed, 1 IA, ultimately repetition, whether it is allowed, whether it is dismissed, whether it is disposed of. It's a practical problem to the court. So please file office objections or upheld.
I may be permitted to then delete my prayer and
Yes,
make
the petition is at liberty to modify to file a amended prayer. Yes. Next.
Chipa, serial number 8, interim order.
Serial number 10.
Interim order earlier granted is extended.
Please, ma'am.
Serial number 10, urgent 11. 11, Parmeshwarappa C.
Morning, it is adjourned. Morning, it is adjourned this matter. This is what I asked for, where they said that the order is not completely recorded.
I appear for the petitioner.
Morning adjournment is not sought in this?
No, Your Lordship. It's not sought. In fact, a notice is not issued. I'm appearing for. Sorry.
So morning in one matter.
I think in others,
No. I will go on that. I remember this. It's already adjourned in the morning. Day after tomorrow or Tuesday or something. It's adjourned. Morning, this matter is adjourned, if you believe.
Only I'm the counsel in this matter, and notice is not issued.
10.
10 is urgent.
I'm for
No,
11.
No, I call 11.
I'm asked 10.
No, ma'am, 10 is urgent.
Yes.
11th matter.
Yes.
Petitioner is seeking for enhancement of the interim
Enhancement of?
maintenance. Your Lordship.
Yes.
The court below has only ordered for litigation expenses and has not ordered.
Notice the respondent and someone's.
Serial number
Once
12.
memo is filed, list the matter.
Great.
Serial number 12.
Appearing for the petitioner,
C.
my lord.
Nehru.
What is this?
Petitioner has been directed to hand over the custody of the minor son.
Take out
Very
notice on the counsel appearing for the respondent
Stay maybe.
and file a memo to that effect. Once the memo is filed, list the matter.
Serial number 13. Anil R.
Yes.
Appearing for petitioners, my lord. The trial court passed an impugned order, page number 22, my lords. There is a finding, my lord, in 125 CRPC. The court has passed ex parte interim maintenance order by stating the reason that page number 21, my lord, after the bold letter. In page number 22, my lord, the court made it clear order passed on this day, subjected to the orders which will be passed on A number 1 after appearance.
What is your income?
No, I'm in search of job, my lord. I don't have job only because the respondent has filed dowry case against me. Whenever I go for any interview, they will check
statement of assets and liabilities.
Yes, already filed, my lord. Already filed. Kindly consider, my lord. Without considering the order, kindly see page number 29, my lord. FLW issued against me. Kindly see page number 29, my lord. Without hearing anything.
So let's see what is there at 29.
Yes, page number 29, header of the page, my lord. I filed application 340, 91, everything I filed. Without considering anything, issue FLW to respondent. That is on 10/9.
When was the notice served on you? This order is passed on
30/12/2023.
When is the notice served on you?
I filed Wakalat on 26/7/2024, my lord.
Then from there to now, what are you doing?
I filed my objection. Many times the court was not there. I filed application 340 and 91.
When did you file your application?
Which one, my lords?
You said no, just now you filed your objections, you filed some application. When was that?
That was filed. Kindly see annexure H, my lord. Annexure H, page number 91. I filed on 28/4/2025.
Then what are you doing from 7th month to 4th? That is 7 years, that is another 6 months there.
No, change of counsel. I was not on record.
Oh, so this will not be considered change of counsel.
No, my lord.
And there is an order.
Yes.
Now that ex parte order, you should have come before this court. That you have not done. Then you waited till almost some say 8 months to file your objections itself. Now when the execution is filed,
I filed my objection and I filed my assets and liability without petitioner assets and liability. That court passed ex parte interim maintenance order, my lord.
then there appears to be no bona fides on your part also, waiting all the while till FLWs are issued.
No, my lords, because without considering any application, without hearing any of the matters, passed FLW, immediately passed FLW order.
Not immediately, after 1 year it is passed.
No, not hearing anything. As soon as they filed the objection for 91 application, 340 application. Kindly see, my lord, page number, annexure M. They filed objection recently. On the same day, he passed FLW. Annexure M, my
What
lord.
is the remedy available to you as on that day? Is the same thing what is today?
No, I want to hear the matter. Before hearing the matter, he passed FLW
Entire
against.
docket proceedings are here.
Pardon?
Entire docket proceedings are here.
No, entire proceedings not here. There only, my lords.
No, where are they? I'm asking. Have you filed the proceedings?
Here proceedings I have filed.
Proceeding
The order
sheet,
sheet,
orders.
order sheet and also typed copy have
Let's
produced. Kindly see page number 31, my 30. Typed copy. 34, my lords. From 2024, what happened, I have produced. The typed copy, page number 34, 35, 36, up to.
It's better we see the main, the original one, because this here we can't even see the dates.
Yes, my lord. Typed copy only I am seeing.
Typed copy is difficult. Let's go to the original one.
Page number 23, 24, 25, 26, even 27, 28. What I filed the application, it is written, and what they filed the objection, that is also mentioned.
Let's see your statement of assets and liability.
Annexure G, my lords.
Let's see.
Page number 81.
B completed in the year 2023. This is Chitra.
Yes, my lord. Kindly see her.
Where is your statement of assets and liabilities?
Page number 81, Annexure G.
MCom in finance.
Yes, my lord.
Monthly expenditure 50,000.
My father is taking care of me now because of the respondent.
Earlier, what you were doing?
I was working in HSBC Bank.
Where is that? What was your income then?
At that time, I was working and my income was only 20,000. Now I lost job. Now I am finding difficult to find my job. They will check the antecedents. When the criminal cases are there, they are not giving any job to me. So kindly see page number 118, Annexure M, N, my lord. Last page, 118. She is more qualified than me. She is an engineering graduate, first class with distinction pass. Page 118, my lord.
Please come. When counsel the petitioner submits that the order impugned is an ex parte order, given without notice to the petitioner, the court had passed an order on 30/12/2023. Immediately after the notice is served on the petitioner, he had filed the objections and also his statement of assets and liabilities. Without considering the said application, the court has issued FLW. It is submitted that the court, after have heard the petitioner, considering the fact that he is unemployed and he has no income of his own, considering the submission of the learned counsel of the petitioner, there shall be stay of all further proceedings pursuant to the order dated. Order passed, order dated 30/12/2023. Same, hand summons on the counsel.
Hand summons memo, my lords. Hand summons memo.
And the counsel, and they shall file a memo to the defendant. Yes. Next. Grant a stay of the proceedings before this court.
And then the order.
What is all this? Yes.
Preliminary hearing B group. Cell number 14, BC Chetan.
For
Petitioner
the
and
petitioner
advance.
husband, my lord. In this, a divorce petition was filed by the husband, in which the interim maintenance was, application was filed by the wife, where the court has ordered for
It is
15,000.
other side.
In this one submission, my lord. Now the divorce has been granted to the husband up to the 4/3/2025. I have paid the maintenance as on date. Only 6 months maintenance is pending. Now the MFA is pending before the honorable
No,
petition.
the writ petition is filed questioning an interim order.
Please.
No, as the divorce itself is granted and the MC is disposed of,
Please.
nothing survives for consideration.
Please.
Whatever it is, it has to be pursued
Please.
by you.
The court has ordered the writ petition. Anyhow, 15,000 was granted by
That
the
we will
court.
not go into
Please.
because the main petition itself is disposed
Please,
of.
it is
It
disposed
is
of.
submitted that the MC number 236 of 2018 itself is allowed and the divorce is granted to the husband.
Husband divorce is granted.
In the light of, as the MC itself is disposed of, nothing survives to be considered in this writ petition.
Same is stayed.
Huh?
Same is already stayed by the.
MFA, they have filed the MFA petition.
That is, nothing survives for consideration in this petition accordingly dismissed.
Cell number 15.
I'm for the respondent in this matter, my lord.
In this case,
Submit
I have
the-
challenged, the husband has challenged this one. 15,000 was granted by the honorable trial court. Now, this honorable court has stayed by granting 10,000 rupees for maintenance.
Correct.
10,000 I have paid the maintenance. No, now they have filed the execution petition. If the petition is dismissed, they will execute once again. The remaining amount has to be executed.
Because we will not decide once it is an interlocutory application.
Please, my lord.
Why will we decide now once a main order itself is disposed of?
Main order is disposed of.
So whatever we can't
Obviously, we are
pass any
entitled for
order
the
in that.
interim maintenance, whatever it is.
Huh?
Obviously, we are entitled for the interim maintenance
That is granted.
till the disposal of that.
Till the disposal of the MFA.
Not, please.
Whatever it is that
Please.
is left to you, please
Cell number
pursue.
15.
15.
For the respondent in this matter, I have
Yes.
submitted as per directions of this court, I have submitted the evidence and cross-examination along with the exhibits of the petitioner, my lord. Lord, the main petition filed by the wife
I'm the petitioner.
is not, the main petition itself is not maintainable, my lord. If my lord
Maybe
turns
let the petitioner start. I'm not sure why my friend is.
Yes.
Yes. My lords, this petition is filed challenging the order, which, my lords, is at page 127. My lords, I'm the wife. I had in my petition, which is based on adultery as one of the grounds, I had filed an application to summon certain documents. That was rejected. And the order, my lords, is at page 127. My lords have found that. May I just read out one or two lines? Application is filed by the petitioner on 28/11/2018 at the stage which was at the pre-evidence stage of the proceedings. Petitioner has filed this application under Order 16 Rule 6 read with Section 151 seeking issuing
Court
of
had
direction.
dismissed it as it is filed at a belated stage.
Actually the finding given is not even belated stage. It is going to take too long.
10,
Yes.
paragraph number 10.
Yes, yes, para 10. May I read from the 10th line or so? So till the completion of evidence, petitioner has kept quiet, and after the case is posted for cross-examination of RW1 respondent witness, counsel for petitioner has prayed about the call for such documents. That is definitely impermissible since the evidence of the petitioner side was closed. Apart from it, petitioner has approached the court in seeking direction on various grounds stated above. Therefore, it is her duty to prove her case with material evidence available on record rather than relying on other sources to prove her case. Therefore, on all these grounds, this court feels that the petitioner fails to make out grounds to call for the above documents stated in the application at this present stage. Therefore, the application deserves to be dismissed. Now, this is the... Now, my lords, may I just request previous page? One more finding given. Just the previous page, page 130, just above para 9. About 2 lines above para 9.
Yes.
About 3-4 lines. So apart from it, the petitioner is seeking production of documents from the custody of various persons who are located at Pune, Mumbai, Goa, New Delhi. These places are very much far away from the court. Therefore, it is very difficult to call such documents from the various authorities stated in the application in the near future. It is a time-consuming process. So that also is given as a ground. Now, my lords, what I want to submit is this application was filed in the year 2018. In the very beginning, even before evidence started. The reason I had filed that application, my lords, kindly see which are the documents. In fact, my application is at page 108. One of the grounds in my divorce petition is that the respondent husband was having an affair with another lady. And at page 108, the documents, I have Xerox copies, printouts. I don't have originals. Now, the documents I wanted at page 108 are hotel records, travel records. In fact, the first one is from the General Manager, E Square Leisure Private Limited. This is booking for Mr. Michael Prince, because he was given different names, along with Komal Agarwal in this from 25th to 28th November. English Deluxe room. Even the second one is Oriental Residency Hotel. I have given the exact date where he has gone and stayed in all these dates with the lady who's also made a party. Now, this is a crucial... Now, the issue, my lords, is that it is not for me to not press it. The IA was already there. In fact, I have given the order sheet. At various times, this IA was raised by me. The IA orders were not passed. It is not that I have filed. And in fact, my lords may see, the respondent filed no objections. My lords may kindly see page 128. His objections also were closed. At page 128, para 3 of the impugned order. Para 3 of the impugned order, page 128. Respondent also fails to file objections to the said application. So he also never filed. In fact, I had filed this application as far back as in 2018, much before evidence started. At various points, in fact, I have produced even the order sheet on the last date to show that the IA is pending to be posted for IA. It was posted for objections on the IA. Thereafter, it was posted for hearing. Even despite that, then COVID came in between. Then after COVID, my evidence started. When my evidence started, I asked the court, let this be ordered. No, you first carry on, then we'll pass orders. Thereafter, finally, I raised it. I said, this IA has to be decided because I need these documents. And then the issue raised, in fact, the order sheet, if my lord has it, I had submitted the order sheet. If I can just hand over, or on the last date, the order sheet, in fact, I had submitted. This was, yes, I can just hand over in case my lords are not able to find it. In fact, on 2020 also, posted for hearing on IA number 5. Madam, this portion. Apologies, one copy, I think on the last date, perhaps I have given it, my lords. So time and again, I have raised it. It is not as if I am trying to raise it only. My lords may just see, this is on 2020, 25/9/2020.
Yes, Mr. Counsel.
So all we want is just one last submission. All we want, my lords, all these can be sent directly to the court by either registered post or even by email from the authorities. It is not going to take time. Now all the electronic records are to be sent. If the hotel
MC of which year?
This, my lords, MC
2018, madam.
2018. In fact, he had raised an issue, there's no jurisdiction. Then the family court said there is jurisdiction. Then he challenged it before this honorable court. This honorable court said, no, there is jurisdiction. So now, my lords, ultimately, it is at the, almost it is over, the trial. But these documents are extremely important, because if the crux of my grounds is adultery and cruelty, all we are asking is that let these documents be used. These are all hotel bookings. He has stayed in a hotel room with another lady who's also a party. Yes. Same lady. So it may be put with a time-bound thing.
These are all allegations, my lord. Even the main petition is not maintainable. If my lordship turns to page number 38 of the petition, of the main petition that she has filed, the writ petition, where she has submitted the the petition that is filed by her at para number 6. Over here she states that the parties had a Hindu Arya Samaj marriage on 22/2000 and subsequently had a civil marriage in the year in UK in 18/3/2000. My lordship, please come to page number 59 and see the prayer in the main petition, my lord. She says granted divorce.
No, that aspect we will not go into, whether the petition is maintainable or not.
When she's made allegations stating that I've come to this honorable court on jurisdiction, I challenge the very marriage over there. The term citizenship was interpreted. Now that judgment came out on 2/2/23, and subsequently, after a month, I started to cross-examine her. My lordship, at page number 108, she has submitted the IA. What she wants is the documents. Now, at para 34 of the evidence, I've submitted all the documents. I would draw your attention to para 34. That is page number 13 of the memo. 1-3, my lord. The memo that I filed with all the documents.
Where is the memo?
This one. This is what they filed.
This is not the memo.
On directions, I've filed this para number 34. What she has stated, I may read out. I state that later discovered, page 13, 1-3.
Sir, on what date you have filed the memo, sir?
On 1st of September.
I think he has filed this, what I've got now. He has given me.
Serve the copy too.
No, I've got it. I've got this copy, what she has given me now.
He is telling that he is filed in the counter.
It's not available.
He is referring to the MC petition which I have produced, which is annexed.
Her in length, my lord. All these documents also there. I've cross-examined her. These are all presumptions. There is no affair that has taken place. Presumptions. This matter is filed in 2018. 2022, she gets a stay on her own case. It is so urgent, she would have moved this court.
Presumption, what is his worry in getting these documents? If according to him it is a presumption, what is the difficulty to let the documents be on record?
I've already cross-examined on this, my lord. I've already cross-examined. Please see.
Yes, it is not come up. My lords, it was not, because it was in B group, it was not coming up.
Page number 13, my lord. If my lordship sees para number 34 of the evidence, what she has stated.
My lords may remand it. My only request with any time-bound directions, even this documents.
The
page number 34.
Served on him in the year 2025.
Sorry, my lords.
Notices are served on him in the year 2025.
In fact, he is the same counsel on record. He was always on record. It was getting delayed because of the respondent number 2. My friend has been the same counsel on record.
If I may permit to read para 34.
2025, await notice in respect of respondent number 2.
Respondent 2, she is the lady.
My lordship,
That is where it was getting delayed.
Mr. Prasanna Subana is a known face in the family court. He's a mediator also. She could have
No,
taken
he is not appearing for her. He is not. There is nobody who's filed.
summons and given it to him, my lord. His name is there on record over here before the trial court.
Like that proceedings were stayed for 3 long years. Very unfortunate. Yes.
Let this be, my only humble submission is it can be allowed with a time-bound direction.
No, when the trial has started, when your application is not decided, why did you keep quiet?
I have not kept quiet. In fact, even in 2020, I have pushed it. I have raised it.
When the trial has commenced. Then
I'll just see.
At that point of time, you could have come to this court. Why did you let the trial go on? Why did you let the...
Sorry, that...
The crux of the matter is there was a joint account. Money has been transferred to the wife.
May I make a submission? My lords asked me the question. Why did I keep quiet? I want to submit, my lords. I have not kept quiet. Initially,
no, when the trial has commenced.
Trial, my lords.
Just filing the application and you can't keep quiet.
No. In fact, I have not. I have raised it. In fact, even in 2020, it is posted for hearing on IA. At my behest, it is posted.
Let's say on 25/9/2020.
Yes, it is posted for hearing on IA number 5. This is IA 5.
This is 4 or 5?
5, my lords. It is posted for IA number 5 and petitioner's evidence.
Call on 2011/2020.
Yes. In fact, it is posted both for my evidence and IA number 5. Then when my evidence was led, again I pushed for it. Please hear my IA. Then the Honorable Court said, you go ahead with your evidence. We will take your IA later if necessary. And the IA was not taken up. In fact, he has not even filed objections. Then my entire evidence was done. Then after my evidence was done, the cross was commenced. Then again I raised it. What about the IA? No, let your cross finish.
My lordship, even in the
immediately he came. The respondent came.
Even in the writ petition 15356 of 2020, which was disposed on.
It is not as if we have sat quiet, my lords. We have raised it.
At page number 125, the Honorable Court has directed
my
that
lords may kindly see one more page. 1 minute, sir. My lords may see dated 6/2/21.
There was expeditious orders, and in spite of that, there was a stay taken by the petitioner. And
if I can just submit an answer, my lords. If I can submit an answer, my lords ask me, kindly see the second last page on 6/2/21. Again, I raised it. Kindly see 6/2/21. Right on top, PW1 and counsel present. Respondent 1 and 2 called out absent. Advocate for respondent 2 absent. Advocate for respondent number 1 present and received copy of IA 5 today from the court file and submitted no objection to allow IA number 5. This is because I raised it. Where is my IA? And he says no objection, allow it.
Where is it?
My lords, this is 6/2/21, second last page of my the order sheet that I give. I can just pass on this, my lords. Repeatedly, I was raising it. Then respondent 2, that is the
no, advocate for respondent number 2 is absent.
No, 1. Advocate for respondent number 1 present and received copy of IA number 5 today from the court file and submitted no objections to allow IA number 5. Advocate for respondent number 2 absent.
Who is 2?
2 is the lady with whom I am alleging that he was involved. Hence,
why you said no objection on 6/2/2021?
Lordship, I already cross-examined on the documents. Please see Exhibit P13, which he has submitted.
I'm asking 6/2/2021. Why did you say that you have no objection to allow IA number 5?
My lord, I need to check the file on that, my lord. Whether
it is there in the court. It can't be. You cannot get any paper, other paper than this. Court proceedings.
Due to this, there were no arguments because he said, I have no objections.
Please come. Agreed by the orders passed in INM. But still, there appears to be something wrong with your client who has kept this matter without even completing the services, without pursuing the matter
No,
for 3
the
long
the
years.
only difficulty for service happened because the lady's address changed. The lady's address that we had in the MC petition, which we have placed in this writ,
I'll record
changed.
that any kind of, the tactics from your client in dragging on the matter.
No,
for
yes.
Every adjournment,
Yes,
10,000
no,
costs to be
we will
imposed.
not adjourn. In fact, we want to
Agreed with
close
the
it.
orders passed in INM.
We will not seek any adjournment. The cost may not be put, but my lords may put conditions. My lords may definitely put conditions. We have no difficulty.
Agreed with the orders passed in I number 5, dated dated 14/10/2022, whereby the court had dismissed the application. The wife is before this court. The wife had filed the MC seeking divorce on the ground of adultery and
cruelty. Yes.
Adultery and cruelty. In that, she has filed an application, that's I number 5. Where is that application?
My lords, the application is at page 108.
She has filed an application on
My lords, the application was filed on.
There are no dates at all.
I will give my lords. The date is in the impugned order, 28/11/2018. 28/11/2018.
28/11/2018, whereby she saw certain dog. She sought for a direction to certain hotels to produce the documents to show that the husband was living in adultery and he has lived in those particular hotels. The court had dismissed the petition by order impugned on 2 grounds. One is that it is filed at a belated stage. Number 2, all these hotels are outside the jurisdiction of the court and it will take some time. Senior counsel appearing for the petitioner, wife, submits that this application is filed in the year 2018 and the petitioner wife expressed this application on several occasions, which is evident from the docket proceedings. It is stated that it is submitted that on 6/2/2021, in fact, the counsel appearing for the husband had stated that he has no objection to allow I number 5, and the same is recorded by the court in the order dated 6/2/2021. It is submitted that when he has no objection for the said document, the court ought to have allowed the same. It is submitted that those documents are very crucial for the wife to establish the grounds on which she is seeking divorce. The court, without properly appreciating the facts and circumstances of the case, had dismissed the petition. Next para. Learned counsel appearing for the respondent husband submits that this writ petition is filed in the year 2022 and the wife had obtained stay of all further proceedings of the MC, which she has filed seeking for divorce. It is submitted that when the chief examination is when the cross examination is completed and the matter is coming up for the respondent evidence, at that point of time this application is at that point of time this application is pressed by the wife. Court had rightly dismissed and no useful purpose would be served by allowing this application. Only for the purpose of dragging on the proceedings, the present application is filed. Next part. Having heard the counsels on the side, what is the material? Having heard the senior counsel for the petitioner, and when counsel respondent for some material on record. The wife had filed the MC seeking divorce on the ground of cruelty and adultery. The MC is of the year 2018. In the same year, she has filed an application, that's IA number 5, seeking a direction to call for certain documents from the hotels to show that the husband was staying with the second respondent. It is a case that she already had the Xerox copies, but for the original documents, she filed this application to summon the said documents. This court has perused the docket proceedings. The docket proceedings reveals that on several occasions, this application is pressed for by the wife. And also, the proceedings dated 6/2/2021 reveals that the husband has stated that he has no objection if this application is allowed. Now, by virtue of this order, the application is dismissed on the one ground that it's a time taking. But ultimately, from 2022 till 2025, the suit is stayed. The entire proceedings are stayed, and it has taken 3 long years. When an IA is filed in the year 2018, why the court had not considered the said application? And when even before the trial is commenced, that application ought to have been considered by the court, considering the fact that the case is filed by the wife seeking divorce on the ground of adultery, and these documents are appears to be necessary for the adjudication of the dispute between the parties, and also in the light of the fact that husband has no objection to call for these documents. This court deems it appropriate to pass the following order. The order dated so and so is set aside, and the IA number 5 is consequently IA number 5 is allowed. Number 2, the wife shall not ask for any adjournments, and the court, whenever adjournments are sought by the wife, the court shall view the same seriously. The application, the main MC itself shall be disposed of as expeditiously as possible, but not later than February 20, September, January 30th.
Grateful, much. Very grateful.
Yes, sir, petitioner, I'm filing a memo for withdrawal of the petition.
Take that. The memo is filed stating that the criminal miscellaneous number 48, criminal miscellaneous within bracket FC number 48 of 2020 has been settled among the parties. Hence, the petitioner wants to withdraw the petition. Memo is taken on record and dismissed as withdrawn. Yes, next.
Petitioner, my lord. This is the husband petition, my lord. The parties are exploring the settlement before the trial court, my lord.
Is it so?
That's what I mean. I have not contacted the client, your lordship, but he has informed me that.
It is submitted that there is a likelihood of settlement. This is the matter on 16th of October. Yes, next.
Interim order can be extended, my lord.
Interim order earlier granted is extended.
Cell number 18.
Yes, what are your instructions?
On the last date, with respect to mediation, they have refused with mediation, but they have given a counter proposal.
Give to her.
Madam.
Take that. You go through that and submit. When do you want?
Let's Monday or Tuesday.
Then counsel for the respondent submits that his client has come up with a proposal which is served on the counsel for the petitioner and also filed before this court. Then counsel for the petitioner submits that they'll go through the proposal and get instructions in that regard. List the matter. Monday, you said Monday also more matters.
Monday, no.
Monday. Great. Yes, next.
Macham.
Cell number 19,
Is adjourned in the morning.
19 adjourned, cell number 20.
But not
40
informed to
Jayashree,
me.
Ravindra.
He didn't inform.
No.
What was it? Just look at it. What is in every matter I ask whether it is informed to the other side or not. Is it recorded in the morning that it is informed to the other side?
He told that yes.
Hmm. It seems he has some medical emergency.
It's all right.
Yes,
Is
next.
it any date? It's
Date is on 22/9.
22.
22/9.
Yes.
Number 20.
I appear for the respondent.
I appear
in
for
this matter.
petitioner in this case, Your Honor.
I'd like to file certain documents which is already filed before the family court. The assets and liabilities filed by both parties.
Yes, yes. Please come to the impugned order. Where is it? Respondent shall produce documents.
Your Honor, this petition has been filed against rejection of order which is passed in IA number 8.
I'm
by the
asking
family.
where is the impugned order, which is the page number?
Page number is 100, Your Honor.
Yes, come to the operative portion of that. 111, 111,
Your Honor.
111,
111.
operative portion of the order. Please come to that.
111.
The respondent shall produce documents pertaining to her employment and salary, and the documents, if any, in connection to the movable property of so and so.
111.
Purchase Sneha. Why are you questioning this order?
Your Honor, we have filed an application under section 16, order 16 rule 7 for production of documents from the petitioner, who is the respondent in this writ petition.
Who is the wife? Who is husband?
Wife is respondent, husband is petitioner in MC case. He has filed for divorce against wife.
So simple.
Your Honor?
It is so simple to say.
Yes.
Husband has filed the MC.
Yes, Your Honor. So we have also filed maintenance application under 24 of Hindu Marriage Act. At the time of filing maintenance application, we also filed objections to main petition, and the same is recorded in the order sheet as well. But while passing orders in IA number 8, it has been stated that we have not filed, respondent has not filed assets and liabilities and directed to file assets and liabilities from the respondent. But we have already filed long before only.
The court didn't say like that you have not filed. You have not filed as per the judgment of the apex court.
We have filed, we have furnished all the assets and liabilities along with relevant documents.
Please come to that order again. 111 order.
IA number 6.
The respondent shall produce documents pertaining to her employment. Where did you file that document?
Your Honor, she is a housewife. She is not working anywhere. We have stated in our assets and liabilities also. She is having 6-year minor child, girl child. She has to take care of the child. That's why she was not working. And even presently.
Do you have any mobile properties?
Movable, no, Your Honor. Immovable, which is gifted by the mother, her mother. So she is not working. 6 years child she is having. She has to take care of the minor child. So she is not working for that purpose. And we have stated in assets and liabilities affidavit also. We have mentioned, we also enclosed.
Where are they? Let's see. What did you file?
Along with the memo today, I have filed the assets and liabilities filed by both parties.
That's
to
what
show
I'm
that
looking at. Page number?
Page number 2 onwards is the assets and liabilities filed by the petitioner in this
wife.
Yes, by the wife. And then under IA number 6 at page number 10, she files an application under which she files documents. So first she files only the affidavit, subsequently documents came to be filed. She has filed income tax returns, which is at page 14. The woman is a physiotherapist. She holds a master's degree in hospital administration, and she's filed only one ITR returns, which is for year 22,
No, she's saying
23.
that she's a housewife.
Your Honor.
Just now you said you are a housewife.
She is a housewife because she has a 6-year-old small
Then
child.
ITR returns, why are you filing when you don't do anything?
No, she's not working, Your Honor. She is a housewife.
Presently, she may have stopped working, but while she was married, as long as she was in the matrimonial home, and even subsequently, she has earned. And while she was living with me, she was earning ₹1 lakh a month. She holds a master's degree in hospital administration. The minute the application came to be filed for maintenance, she stopped working. But the
When the dispute started between the parties?
this is the petition is of 2021.
MC is of which year?
Of 2021.
MC is of 2021.
Yes.
IA for maintenance is filed when?
IA for maintenance is filed by the wife respondent on
2022, 11th March 2022.
18/2/2020. 18th March.
2022. According to you, she's working till when?
According to me, as long as she was in the matrimonial home, and even subsequently she was working. So the whole of 2021. I'm aware that she was
What
working.
is relevant is, now this petition is filed in 2022. So 21, 2019.
Yes.
Is she working?
Yes, she was working, and she does not produce anything to show that.
She was working before the birth of the child, Your Honor.
When is when the boy is, when the child is born?
Girl child. Petition. Objections. Your Honor, one small correction. We have filed a maintenance application of 18th February 2020.
What I have been given, it
It is
indicates
stated
the
in
date
the-
of 11th March at page number 36.
It is stated in the order sheet. Kindly check 58 page number of the petition, Your Honor. It is stated in the order sheet.
Page number 36 says 11th March, which is why I mentioned 11th March. Can I also just read one para of the synopsis that they have
We'll have
filed?
some other day. It's, this is smarter. Give some other day in the next, in that 15th week, September 15th, that week. Yes, next.
Yeah, good.
15th. Yes. That week, someday. Yes.
Cell number 21.
Well, in this case, appear for the petition, Malala. Last occasion, your lordship had directed to file a calculation memo, already filed, Malala. And also, there is a settlement of possibility of settlement, Malala. Matter may be referred to the mediation.
It may be referred to mediation.
Both the parties were Bangalore or?
Bangalore.
Both the parties submit that the matter may
Date may
there's
be
likelihood of
fixed.
settlement. And the matter may be referred to the Lok Adalat.
Date may be fixed
Officially,
later.
both the parties shall appear before the Lok Adalat on 11th September.
Yes, Malala.
Yes, next.
What's up?
Cell 22.
11th
For the
September before
petitioner.
Lok Adalat.
Petitioner has challenged the interim order of maintenance, my lord.
This
Family
is which serial number?
22.
22.
Give the file. Yes.
Operative portion of the order is at page number 26, my lord.
26.
26, my lord. The family court has directed
20,000 per
20,000
month
per
from the
month.
date of order till the disposal of the case. Yes.
Both the petitioner as well as the respondent are government teachers, my lord.
Hmm.
She is earning a sum of rupees 62,000. I am earning a sum of rupees 64,000, my lord.
Hmm.
But the respondent, my lord,
Children
2 children, my lord.
are with the wife.
With the wife. They are also studying in the same government college where she is working. Government college. My lord, she voluntarily takes transfer to Shivamogga by deserting me, and she blocks all my contacts. I will try to contact her. She will never turn up. I will issue legal notice. She will not turn up. Thereafter, my lord, I will file a MC petition, my lord. After filing the MC petition, she files another petition for maintenance, and the maintenance was granted. Sum of rupees 20,000 was ordered, my lord. Lord, my humble submission is that, my lord, when the wife deserts without any reasonable cause, my lord,
That we will not decide.
please,
at
please,
this
please,
stage.
please, my lord, please, my lord.
Next.
He is paying a sum of rupees 15,000. It was a joint loan taken by the husband and wife for the purpose of purchasing the site, my lord. I am paying 15,000 EMI, paying 10,000 rent, my lord. And apart from that, my lord, I am paying Sukanya Samruddhi Yojana for the kids up to 1 lakh for one child, 2 lakhs for another child. All those things I am bearing, my lord. Lord, 20,000 is much on a higher note. It may be reduced to 8,000. That is my humble submission.
8,000.
My lord, my humble submission would be, the petitioner is also government teacher. Respondent is also government teacher. Their marriage was solemnized in the year 2011. In the year 2013, they have separated because of the cruelty done by the husband. Several allegations I was made before the trial court. That has to be decided by the Honorable Trial Court. Now my application before the Honorable Trial Court, my lord, kindly see, for the reasons stated in the accompanying affidavit, it is most respectfully prayed that this Honorable Court be pleased to direct the respondent to pay interim maintenance of 30,000 per month until disposal of the above case towards the shelter, food, clothes, and education and miscellaneous expenses of the petition number 2 and 3. Only for the two daughters, I sought for the maintenance before the trial court, my lord. The Honorable Trial Court rightly passed the order 20,000, 10,000 each to the both the petition number 2 and 3. So there is no interference.
Do you deny the fact that he is paying all that?
He is not paying anything, my lord.
What to the, there is a some loan they have taken for purchase of some property.
That 7 lakhs loan was taken by both the jointly.
He is also not
No,
deriving any income.
no, my lord. He is not paying any single NP for EMI since from the date of separation in the year 2023. What are the submission or totally false submission? He is not making any single payment towards the EMI. She only making payment, for which we have produced the material before the trial court also. It's totally completely. If you having any documentary proof for making of payment for EMI, let him produce.
I will furnish it, my lord. If your lordship direct, I will furnish it, my lord.
When you can furnish?
Next week, my lord.
This is the matter next
Any
week.
date may be fixed,
Yes.
my lord.
By the time then Counsel, the petitioner shall place before the court the document to show that for the loan that is obtained for purchase of a site in the joint name, he is paying monthly EMI of 15,000.
15,000.
Number 23, adjourned. 24. Ganesh B. Nayak.
For respondent,
Petitioner or none?
may be permitted to say one thing, I have not received the petition copies.
I have served. I have served in the trial court, the counsel,
You give
as per
him-
the direction of the court.
Counsel, the petitioner shall serve the copy of the writ petition on the counsel for the respondent. Give a date next week.
11.
Oblige, my lord.
Yes.
Cell number 25. Revati Adinath Narade, a petitioner.
Appear for the respondent.
Vijeta Nayak. as
Your lordship,
respondent.
the matter may take some time. Any date in the next week may be granted.
I have no objection.
11-9.
Yes.
Cell number 26.
I appear for the. Well, this is the matter your lordship wanted me to file an affidavit. We have filed the affidavit, my lord.
Sister Gondraj, is this
The
sufficient?
affidavit they have filed says, well, your lordship may kindly recall, 50,000 rupees is deposited with the 50 lakh rupees. They say if it is,
11-9.
if anything happens to the deposit where it gets diminished or they're not able to secure interest, then he'll go on paying monthly. That is not the agreement between the parties. The agreement with
Where is the affidavit listed?
no, at page number 12, is where it starts. The relevant portion is at page numbers 18, 19, and 20.
In the event of Canara Housing Development Company in which the amount of rupees 50 lakh is invested by me,
Yes.
want to be closed, or if anything happens to that company, it would be my responsibility to ensure that the respondent will receive the monthly maintenance.
No, the settlement agreement signed between the parties is that he will make a deposit, the corpus with
Yes,
which the
my
interest.
lord, I find the affidavit. I will deposit, my lord. I will see that he gets the money. My lord, I do not know why my learned friend is doing this. Yes, my lord, the question before your lordship hails from a judicial family. Great father was a chief justice of this Karnataka. Grandfather was the chief justice. Father was the advocate general. I have undertaken, I have deposited 50 lakhs. Apart from that, I have deposited 25 lakhs each in two different banks. I undertake to pay. Apart from that, my lord, I am paying 16 lakhs per year for education. 6 lakhs, 9 lakhs for tuition fee, 4 lakhs for transport. This is the amount I am spending. I have bought a house for 3.5 crores. I do not know why. I have paid, given the house. I have undertaken to pay tuition fee. I have undertaken to pay travel fee 16 lakhs per year. That also I am paying. Apart from
When
that,
you are,
I have
no,
to
when
pay.
you're, no, when your client is doing so many things, what is the difficulty to just file an affidavit as it is required?
I have filed the affidavit, my lord.
It's filed. It is the, you
I
should have
filed the
said,
affidavit, got the copy,
no,
my lord.
I will, that
I will
amount,
send the copy.
I will deposit that 50 crores, 50 lakhs amount. And from that,
According, yes, my lord, I will deposit, I have said. I have undertaken to deposit in the event of this Canara banking goes, my lord, if it goes, something happens, I will undertake.
senior counsel, please read the affidavit at paragraph number 3.
Para 3 of the affidavit, ma'am.
Well, I have filed the affidavit and served the copy on the other side. If
Paragraph
it's
number
not there,
3.
I will give another copy, my lord, if they have not received.
Ma'am, please, court is asking to read the paragraph number 3 of your affidavit.
My lord, that's the first affidavit. Thereafter, your lordship directed me to file a second affidavit. That also I have filed. After that, your lordship directed me to file an affidavit.
Read that.
If it's not there, my lord, I undertake to give it to another copy, my lord.
No, it is there.
Mary Paraphone. I respectfully submitted according to clause A under the heading of alimony maintenance of the memorandum of settlement dated 24/2017, deposit of 50 lakhs made in Canara Housing Development Company in favor of the respondent herein. In the event that the said company were to be closed or if anything happens to that company, it would be my responsibility to ensure that the respondent would receive the monthly maintenance which he is now receiving. But your lordship may kindly see the terms agreed between the parties. There must be a corpus to be deposited which fetches this interest month on month. And my lord, after 10 years, I have the right, my lord, to withdraw the deposit. Right now, my lord, lordship kindly see paragraph 9 of the.
No, what has to be added at clause number 4 is that they would ensure that again that 50,000 corpus would be deposited in a financial institution where from she would be getting the amount.
No, but lordship kindly see paragraph 9 of the writ petition. They've given the deposits they have made. Paragraph 9. This 50 lakhs is fetching per month 75,000 rupees. Another 50 lakhs deposited in the bank is fetching 30,000 rupees per month. So this 50 lakhs, my challenge is to the deposit of 50 lakhs before this Canara Housing Company because they're offering 18% per annum interest. It is not a secure deposit. If anything happens to this deposit, let them make a deposit. Let them make a deposit.
Financial institution approved by the government of India. It's a regular, approved institution. In the event of something happening, I undertake.
Let them make a deposit. Canara Housing or bank or whatever it is. Let them make a corpus deposit. Lordship will kindly see the.
That's what I'm saying. I'm saying in that clause number 4, that should be the addition.
But if your lordship sees the other clause, clause D at internal page 9 of annexure A. I'm sorry, I don't have the page numbers. The memorandum of settlement signed between the parties. Clause D says, for 10 years after the corpus is deposited, I will not be able to withdraw. After 10 years, the entire corpus comes to me. And the corpus...
The order passed by this court. Earlier an affidavit is filed. As the said affidavit is not clear and is not in consonance with the earlier terms of settlement between the parties, this court has directed the respondent to file an affidavit even the affidavit that is filed also is not in consonance with the earlier settlement between the parties. Where is that settlement?
Internal page 7 of the memorandum settlement, not annexure B.
Annexure?
Annexure B in their writ petition, not, I don't know.
Take out their writ petition next.
No, if it's my writ petition, I have the page number.
Hmm.
That page number 18, alimony maintenance. Page 18.
18 is the order sheet.
But in my writ petition, if it's their writ petition, not, then it's after the order sheet is the memorandum settlement. As per-
Ma'am, 17, 16, my lord.
17764.
No, man, I have to decide the type of investment. That is the undertaking I have given in the compromise. I will undertake. I will decide where I have to deposit.
Page 18.
Page number?
18. Clause A.
Clause?
A. Alimony maintenance. Page 18. On the making of a decree for divorce, the petitioner shall make monetary deposits in the name of the first respondent and minor son in the ratio of 60-40%, which shall fetch a minimum monthly return of 1,10,000 rupees to be utilized by the first respondent for living expenses for herself and Nitan. The said deposits are to be made in 3 installments for investments, which shall yield the aforesaid return. The petitioner shall also draw a check of 50 lakhs, favoring the first respondent towards the first installment, which shall be held by the first respondent's advocate on a bank account being established in the name of the first respondent with a cooperation.
Clause A.
Well, then clause D.
Of alimony maintenance, an amount of rupees 50 lakhs shall be deposited
As the first installment out of 3 installments.
as a first installment, and the husband shall decide the type of investments. The affidavit that is filed simply says that clause 4 of this, I kept a star extracted. As per that, the respondent is not clarifying, the husband is not clarifying that in case this that Canara, if something, Canara Housing Development Company, if it is to be closed or if anything happens, then the petitioner, the husband shall deposit that amount of, shall ensure for that amount of 50 lakhs to be deposited in a financial institution, whichever is of his choice, which is recognized by the Reserve Bank of India.
Fetching 18% interest, because this is fetching 18%.
Which is fetching 18% interest in whichever bank he is interested, as ultimately as per the clauses, he is the person who shall decide the type of investment. In that regard, a clear affidavit shall be filed before this court. This is matter on September 23rd. Yes, next.
Till number 27. Till number 20.
Lord, I appear for the petitioner.
Yes.
With Lordship, kindly, I appear for the petitioner. And if Lordship kindly recollect, this is the husband's, the father's visitation rights seeking, my lord, where the wife has filed a false POXO case. And your Lordship heard of it at length.
Lord, senior counsel has been engaged in this case. May I request a short accommodation by Monday?
Yes,
on Monday, my lord.
Obliged.
And may I request it to be a further hearing, my lord, because your Lordship was pleased to hear.
Hearing, only I just wanted to let it be in the same caption. Yes, next.
Number
Very well.
28.
Appearing on behalf of the respondent, my lord.
I appear for the petitioner.
My lord, we have filed the wakalat, but there seems to be an office objection insofar as the wakalat is concerned. We have filed the wakalat on 22nd August itself.
Yes.
My lord, they have filed a writ petition. I would just like to invite my lord's attention to their interim prayer, my lord.
Let him argue.
Please,
Yes.
my lords. Please.
In fact, there's a petition. my
Before
lords,
before
filed
he
by
argues,
the-
my lords, just one submission, my lord. Let me place my objections on record.
Objections. No objections are required in a writ petition. Yes.
Please, my lords.
Very simple order.
My lords, there's a petition filed by the father, which is at annexure
My lord,
A,
there
my
are a
lords.
lot. I'm very sorry. There are a lot of allegations which have been made which are unsubstantiated.
Consider any of the allegations. We will go by what is the impugned order, what is the affidavit, what are the objections to that. Yes.
Please, my lords.
Where is the impugned order?
The interim order, my lords, is at annexure H, annexure G, my lords, at ink page number 144. But 143, that's the reasoning, my lords. In fact, an application came to be filed by the petitioner seeking for interim custody of the minor child, my lords. Pardon, my lords?
140, where is the?
143, my lords.
Hand over the custody of the minor child.
Yes, my lords.
And seeking initiation of criminal proceedings is hereby dismissed.
In fact,
Liberty to make audio video call to his minor son once a week, about 30 minutes. Please come to your petition. Where is that IA?
please, my lords. That is at annexure C,
Page
At-
number.
ink page number, my lords, 29.
You are for the father or the mother?
Apologies, my lords.
You're
It
for
is
the-
29 is the objections, 26 is the application.
For handing over the custody of minor child
Yes, my
to
lords.
the petitioner and also pass the necessary orders. Why should the order of changing the custody be passed?
Two reasons, my lord. One being,
What is the age of the child,
now the child is 6 years old, my lords.
male or female?
It's a male.
Hmm.
Two
When
reasons,
the-
my lord.
When the GNWC is filed,
2023, my lord. 2022.
2022. Any MC is filed?
No, my lords. In fact, earlier MC was filed for
When the-
restitution
when
of
the wife-
conjugal rights.
When the wife had left the matrimonial home along with the child?
Yes, my lords. That, in fact, if I may bring to my lord's attention to ink page number 60, 60, my lords.
Hmm. Hmm.
This is the order sheet extract.
Hmm.
The fourth paragraph, my lords.
Hmm.
In fact, when the case was filed, the child was residing within the jurisdiction of this court. Now the child is ordinary resident of Madhya Pradesh. What has happened, my lords, is this. Earlier MC petition was filed by the petitioner for seeking restitution of conjugal rights. That was also decreed by the Honorable Trial Court. But the respondent did not even comply with the said directions, my lord. Unfortunately, the petitioner had no other go but to file for GNWC case before the Honorable Trial Court, my lords, seeking the custody of the minor child. In the course of the petition being filed, the child was shifted to the Madhya Pradesh state itself, my lords. That, my lords, I do not have the date at which the child was shifted, my lords, but the order sheet clearly states that at the
Before that, no visitation orders were granted to you.
when the petition was filed, it was granted, my
The
lords.
visitation that was granted.
In fact, the visitation, my lords, that is at ink page number 55, my lords.
Yes, what is it you can tell?
That is, my lords, the last paragraph shall have access to the minor child who's in the custody of the respondent. He can meet the child on every Saturday morning from 9 a.m. to 12 noon. And he can talk with the child through phone and WhatsApp video call.
M2, 12 noon.
12 noon. Yes, my lords.
Then when the child is shifted from the custody of from the jurisdiction of the court, what did you do?
Immediately, my lords, what had happened, I sought for video call, relief, my lords, so that I can have at least a video call visitation contact rights with respect to the child, my lords.
Brought to the notice of the court?
Yes, my lords.
No. When she's shifting the child from the jurisdiction of the court.
Please, my lords.
When there is an order of visitation to you on every Saturday.
Please, my
Was it brought to the notice of the court by the mother?
No, my lords.
This was an ex parte order, madam. This was an ex parte order, my lord. I had not even entered appearance. They filed the GNWC case. They obtained this order by the time I received notice.
When did you shift the child?
My lords, well before this, my lord. My lords, the respondent is an ordinary resident of Madhya Pradesh, Singrauli town itself, my lord. Only after she got married to the petitioner did she shift here.
When did you shift to Madhya Pradesh again?
I will provide the date, exact date. Precisely, I'll provide the date, my lord.
After institution of the GNWC proceedings, my lord.
My lords, my instructions are that after she had not even received notice before that, because her father, her mother, her brother, all of them are residents of Singrauli, Madhya Pradesh, my lord. She was here with her husband in Bangalore. After there was matrimonial discord. For a period of 2 years, I believe, my lord. I will bring it to the notice of this honorable court, my lord.
When the child was born,
The child was born in 2018, my lord.
then his ordinary place of residence is Bangalore only.
Back in 2018, my lord.
Because he was born in 2018.
Please.
Here till 2020.
However, my lord.
When the GNWC is filed.
My lords, one more thing I would like to bring to this honorable court's notice. She is a doctor by profession, my lords. My lords, one more thing I would like to bring to this honorable court's notice is that when this order was passed, the honorable trial court had asked the mother and the child to be present before the family court on one instance due to her mother's illness, who has now passed away. She was not able to bring the child before the court, and pursuant to which the trial court had immediately ordered custody of the child to be transferred to the father petitioner, challenging which we had come before this very court, wherein my lords only had passed an order, and my lords can find that order. They have only produced that order, my lord.
Page number 79.
73, my lord.
My lord's observation is at 79.
Let me conclude, sir.
Fourth line from the top, my lords, in page number 79.
My lords can directly come to 80. My lords, we fairly admit. I will only admit, my lord. I will only admit there was an observation.
Let us read it.
Please. There was an observation by this honorable court that I hadn't complied with the order of the family court, and later on, my lords were pleased to pass the order at page number 80.
At 79, my lords.
My lords, after this honorable court passed the order, I've been diligently following the orders. I entered appearance, I filed objections, and let me complete, sir.
Sir, I was arguing, and that's when you came in between.
That was an ad interim order. You did not mention it to the court. If I may just bring it to the notice of this honorable court that, pursuant to this order, this IA number 8, which is all again in question here before this honorable court, we argued on merits before the trial court. The trial court rightfully dismissed that application.
So what will happen to the father's visitation?
My lords, there is one more development to this case, my lord. There is a contempt petition that is filed with respect to the very same thing. They are forum shopping at this point in time. If we don't get relief here, we'll go to another court. If we don't get relief in that court, we'll go to another court. This is what they've been doing. This is essentially their modus operandi. They go before the family court.
What is the mother's modus operandi?
She is able to provide the my lords, if I may mention one thing, my lord, if I may be able to mention one thing, there is an interim order that is passed by the contempt court, which we have been following diligently.
What is that order?
If I don't have that order copy with me, my lord, I will produce all of these things. One short date may kindly be given. I will produce all of these things.
In fact, every day, the honorable coordinate bench, my lords, had passed an order stating that every day I should be given a contact rights of 1 hour to talk to the child.
Which is being given.
I am not being able to do so. Unfortunately, I'm not being able to do so, my lords. Every day, the petitioner calls the respondent, it's unanswered. If the petitioner calls the father-in-law,
What is the timing?
between 5 to 6 in the evening, my lords.
So that has been modified.
They submitted that. There was an order passed in the contempt proceedings where the father is permitted to speak with the child every day 1 hour between
6 to 7. That has been modified, my lord, due to her working schedule.
6 to 7.
6 to 7.
It's between 6 and 7. It is the grievance of the father that the wife had not followed the said order, and he is not able to communicate with the child who is in Madhya Pradesh. Then counsel appearing for the respondent submits that they have been complying with the order of the court, and the counsel of the respondent mother seeks time to file certain documents before the court. In that view of the matter, this court is passing the following order. As per the order passed by a coordinate bench of this court, it's for the division bench.
Please, my lords.
Order passed for the division bench. The mother shall comply with the same till further orders or pass, the mother shall comply with the same, or else considering the conduct of the wife, appropriate orders will be passed in this case. List this matter on.
May I request for 2 weeks, my lord, to place the documents. I will comply with the order both in letter and spirit till that day, my
This is
lord.
the same defense taken.
Will list this matter on 24th. On the day, every day, evening at between 5 and 6.
6 to 7.
6 to 7. The father shall be, and if necessary, the father can record the call also to present before the court on the conduct of the mother.
Please, madam.
Number
Yes.
29.
Much obliged.
Grateful, my lord.
Vijay Nandalike, Arun Govindraj for respondent.
The response.
Very settled, my lord. So there is one, everything is complied.
Hmm?
Everything is settled, my lord. So
Matter was referred to private mediation, but we have to execute the agreement. That's all Mr. Prashant Chandra has not been able to.
weeks
When
time maybe.
finally,
Within 1 week, I think
Within
the
a week.
agreement is finalized.
list the matter on 25th.
But by 10th, the agreement only has to be signed. It's
The
ready.
court has no difficulty because it's at least 4 times it has come up before the court, this matter.
Yes. But by 13th or 15th or 16th,
List the matter on 15th.
16th, sorry, 16th.
16th, it is submitted that parties have entered into a settlement and that will be placed before the court.
Please.
Yes, next.
Case number 30. E. Ravishankar Shastri, petitioner Ashwin.
My lord, the impugned order is
Have an
directing
interim
the,
order.
it is there, my lord, till date interim order is there.
Interim order earlier granted is extended until further orders. No representation on behalf of the respondent. There is this matter in the month of November. Don't give the date. It's 31.
Case number 31.
With the respondent appearing for the petitioner, my lord. My lord, it's a father's appeal challenging the visitation order, my lord. Why, my lord, I have sought for overnight custody. The son is 9 years old, my lord. But there is no any reason assigned why it has been denied. Only it has been granted me on Sundays, 10 to 1, my lord. 3 hours per week.
From how long you are exercising this?
As per the from 24th June 2025, my lord.
Then what is urgency for immediate overnight
My lord,
custody?
my overnight visitation has been denied. Number 1, my lord.
No. From how long the parties are living separately?
From December 2024, my lord.
December 2024.
Please, my lord.
When did you file the GNWC?
It's our petition, my lord.
When did
He
you
has
file?
filed December, my lord.
That is in the month of
24.
2024.
Please, my lord.
When did you file the IA for visitation?
March, my lord.
March. Granted in the month of July.
In June, my lord.
June.
Please, my
So June, July, this order is passed.
June, my lord.
What is the urgency?
Lord, the
No. First of all, there is a gap of almost a year.
Please, my
Let
lord.
it go on for 2-3 months. Then you can renew a request for that. Okay, basing on the comfort zone of the boy, how
The boy is,
comfortable he is.
is very much comfort, my lord. That is my submission here. Even the findings of the trial court, there is no any serious allegation as per even it
What
has
are
come
your
to the
instructions?
conclusion.
My lord, here, page number 14, my lord, the order, the honorable family judge has interacted with the child. So the child has mentioned that I want to stay with my mother. Every day they have video calls, they have phone calls, they talk for more than 30
Oh, yeah,
minutes.
of course, who is stopping you from not staying with the mother? He will be with the mother. But why not a work when no serious allegations? Why not we grant overnight custody to
My
the
lord,
father
let
on
this
one
go
day?
on for few days, my lord. Instead of pushing the child, let him only ask for overnight, my lord. Let the
He'll ask
child
on his own.
not like that, my lord.
Plus, the party shall be present before the court along with the child on 11 September.
Please, ma'am.
Yes,
5 p.m. in chamber.
5 p.m. in the chambers.
Please,
Yes, 32.
Case number 32. Yoganna KP.
I appear for the respondent, my lords.
Come for the petitioner in this matter.
Yes.
The husband challenged the interim order passed by the trial court, my lord.
Where is that? Which page?
My lord, page number 50, my lord, Annexure H. The petitioner is an agricultural coolie, my lord.
How much is granted? 20,000.
Please.
And what is
10,000, my lord.
10,000 is it, yes.
10,000? She sought for 20,000.
Please,
Please,
ma'am.
Hmm. Respondent is a MA graduate.
Please, madam.
Why are you doing working as agriculture coolie?
Because my lord, at the time of marriage.
So that you should not pay maintenance to the wife. How
No,
can
my
you
lord.
say MA graduate?
Kindly-
Like, he says working as a coolie.
And also he has obligation to maintain her mother. She is admitted in the hospital now. She is an
That is a
unconscious.
different story.
Kindly see the photo, my lord. Kindly.
No,
kindly
we will see that. Then why? How will you?
And
how
also
will
the
you
medical
maintain?
bills, my lord. He is an
My lord,
agricultural.
petitioner has a land.
How are
my
you
lord,
able to pay all those bills when you are a coolie?
My lord.
You say that you are a coolie. How you are able to pay all those bills?
My lord, he is
Have you
raising
filed
some
a
law.
statement of assets and liabilities before the court?
No, my lord. Both are not filed any assets and liabilities. In spite of the trial court has ordered 10,000 to the for the maintenance.
Is this an order which is sent to the R&S when this matter came up?
My lord, page number 40, my lord, for the kind.
Very good. No, very good. Please check whether this is given to the registrar R&S or not. This order. I'll set aside this order and remand the matter to the court. What is the interim order passed by this court?
5,000 to pay 5,000.
Let him pay 5,000 till the application decided. Both of you file your statement of assets and
My lord,
liabilities.
kindly see page number 40, my lord, for a minute.
For what purpose?
Kindly see the photo of her mother. She is bedridden, my lord. He has to take care of all.
That's why file your statement of
Necessary.
assets. The
Kindly 3,000 maybe.
my lord, petitioner has a land. My lord, measuring 10 acres, 12 guntas. My
interim
lord.
application is filed. The orders passed on interim application MC number 96 of 2024, dated 3rd May 2025, whereby the court had granted 10,000 maintenance to the wife. The husband is before this court. It is submitted that he is a daily wage laborer, and the court had granted 10,000, which he is not in a position to pay. When counsel for the petition submits that the court has not, neither the petition nor the respondent has filed the statement of assets and liabilities in spite of the same. The court had granted 10,000. When counsel appearing for the respondent submits that the husband is having, the petition is having agriculture lands and is deriving a lot of income out of that, and the court had rightly granted 10,000. Next para. Having heard the counsels on either side, there is a mutual non-record. This court has repeatedly issued directions to the family court to strictly follow the guidelines issued by the Honorable Apex Court in Rajneesh versus Neha. In spite of the same, the family courts are not adhering to the same. They are not asking the parties to file the statement of assets and liabilities, nor in any of the orders there is no discussion with regard to the statement of assets and liabilities. This order is one classic example for the same. And in the entire order, the learned judge has failed to discuss about any of the guidelines issued by the Apex Court in Rajneesh versus Neha, and a cryptic order of this nature is passed by granting 10,000 maintenance. In view of the same, the order impugned dated so and so is set aside. The matter is remanded back to the family court for fresh consideration. Both the parties shall file their statement of assets and liabilities within 15 days from the date of receipt of the copy of the order, and within 2 months from thereon, the trial court shall dispose of the IA. Till the pendency of the IA, the petition shall pay an amount of rupees 5,000.
1,000 is
33.
4,000, at least 4,000, my lord.
Yes.
33. Neha A. Kalrao, petitioner.
Yes.
Palya.
Appear for the respondent,
For the
my lords.
petitioners, my lord.
Yes.
My lords, filing my statement of objections, my lords, with your lord's permission. Statement of objections, my lords.
Yes, take that. Yes.
Lots, the petition has been filed for the enhancement of the maintenance that has been passed by the Honorable Principal Judge in the Family
It's
Court.
a fresh matter. Enhance of maintenance, no urgency, we'll hear later. This is matter on, in the month of October. Yes, next.
Highly obliged.
Yes. And file it in the registry. Yes, next 34.
Tell number
Madam, date.
four.
Here the petitioner.
Yes.
Next are L, page number 68. The petitioner filed application. Petitioner is the respondent wife before the family court. She filed application IN number 18 to recall the order dated 2/7/2024.
Where is that?
At page number 123, Malay.
123.
My application seeking permission to cross-examination PW number 1
Yes,
was
this
kept
matter
up in.
came up on the other day.
Please, Malay. That
why-
day,
why
Malay,
is it adjourned?
I was permitted to serve the hand summons to the advocate for.
Yes. What do you say?
Your Lordship, may kindly see the order passed by the family court.
I've seen
Lord,
that.
MC petition, Lord, is of the year 2014.
I've seen that.
Successfully, she is trying to drag on the parliament. She is not allowing the family court to conclude the matter. One or the other pretext, she goes on filing these kinds of application. Not unless and until that order kept in abeyance is challenged. Now, he cannot make an application to reopen and recall that order. The family court will become functus officio. He has to work out remedy on the order passed by the, because the learned family court fed up with the attitude of the respondent, and on seeing the successive application, in fact, my lord, the petition is of the year 2004.
No. What do you say? This court passing an order that within a month, everything should be concluded. And she
Everything
should
should
also
be
be
concluded.
given an opportunity to cross-examine.
I have no objection at all, because
Then why
tomorrow
ask?
they should not take up such a contention before in the other forum.
Hmm.
Therefore, now it is recalled. In fact, it is recalled now today. It has been posted for her cross-examination. It is already recalled.
No, madam. PW cross-examination of PW number 1 was taken as nil. Thereafter, I filed application to seeking permission to cross-examine the PW number 1.
Whatever it is.
That application is
If not done, let him do it.
That's what the order impugned will set aside, will permit her to cross-examine PW1, and everything shall be completed within a matter of 1 month.
1 month. If it is already evidence is commenced, let them do it.
1 month, no adjournment. Even one adjournment is sought on the
I will
ground.
not seek a adjournment.
Where is the impugned order?
Impugned annexer L, page number 68. madam.
68.
68.
68. madam.
Annexure L.
Under this order, my lord,
Agreed with the order dated.
paragraph number 9.
Order passed in IA number
18.
IA number 18 in MC number 4423 of 2014, dated 25th March 2025, whereby the court had rejected the said application which is filed to recall PW1 for cross-examination.
Recall the order dated 2/7/2024, under which, my lord, 3 applications were kept in abeyance. 3 applications, one for the seeking permission.
Where is
to,
your petition? Let us see.
my lord,
You have
kindly, one,
completely, your client has messed up the whole things.
page
How
number,
many applications, how many orders, how many times the costs are imposed?
my lord,
And
what
court,
happened, my lord,
neither
in this
you are
case?
able to understand or the court able to understand which is the order to be recalled. Those many orders are there. Where is that order?
Page
Docket
number
proceedings.
123, my lord. Page number 123. Order dated 2/7/2024.
IA number so and so is filed to recall the order dated 2/7/2024, whereby an application that is filed by the petitioner under order 18 rule 17 read section 151 CPC is kept in abeyance. It is submitted that now the case is at what stage?
Cross-examination of respondent.
Examination of
The
no,
cross-examination
he is saying
of
she's not-
respondent. And as because of the health reasons, as a petitioner, you are the respondent or you are
I'm the respondent before the trial court, wife.
as due to the health reasons, she could not cross-examine the PW,
Yes,
the petitioner, the PW1. As such, the same is closed, and the cross-examination is taken as nil. It is submitted that if an opportunity is not given and the case is reopened, and the case is not reopened, and an opportunity to cross-examine PW1 is not afforded, it would cause lot of prejudice to the wife. Then counsel appearing for the respondent submits that, in fact, the court is fed up with the manner in which the petitioner wife is pursuing the matter. It is submitted that the MCs of the year 2014, from 2014 till now, she has made all her best efforts to delay the proceedings, and proceedings, and the court had finally passed the order impute. It is submitted that there are no grounds to interfere with the order. Next para. This court has perused the docket proceedings and also the manner in which the wife is protracting the litigation right from the year 2014. There is a deliberate attempt on the part of the wife to drag on the proceedings. As a last opportunity, though this court is initially not inclined to set aside this order, however, in the interest of justice and equity, and to give a fair opportunity to the petitioner, this court deems it appropriate to grant one final opportunity. Accordingly, this court is passing the order. So the IA number so and so, in MC number so and so, the order dated so and so is set aside. The petitioner wife shall cross-examine the husband, PW1, and the entire suit is permitted to cross-examine PW1, and the entire suit proceeding and the MC proceedings shall be concluded within a month from the date of receipt of the copy of the order. It's number 2. Even if a day the wife seeks for adjournment, for each adjournment, the court shall impose 20,000 costs.
Right.
20,000 costs.
My lord, I will not seek adjournment, my lord. The
Yes.
position of the parties, my lord.
Yes.
My lord, one.
In fact, my side, that is,
Huh?
in fact, my side,
No cross.
petitioner evidence is, entire thing is over. Her evidence came to be discarded because she did not tender
Yes.
before the court for cross-examination. Today, she is very much present before the court. I will do it and I will complete it, not PW1, RW1.
RW1.
Yes,
No,
my learned friend maybe
No.
he has mistaken.
My lord, PW was what I pointed out, my lord, as per the order date 27/2024, my lord, that application was came to be kept in abeyance. PW number 1, my lord, not subjected to cross-examination.
If
That
it
is
is
right.
not done, let him do it.
Please.
I don't have any objection.
I said that's what the entire MC proceeding shall be concluded.
Within 1 month,
It should be concluded.
1.5 month, because judgment, my lord, arguments, and
Whatever it is, let the court do it.
and one more submission is, my lord.
No further submission.
My respondent is my retired police officer. The wife is my suffering from cancer. She is my lord, yes, no means to.
Can't even afford to say one thing. I should have straight away dismissed it on the last occasion.
I remember.
Only to give an opportunity. So no more submissions from your side. Yes, next.
Question number 3, serial number 1, Vaishnavi Hegde.
Cost should be paid before the trial court.
And these applications are allowed subject to payment of all the costs that are imposed by the. Which cost?
No cost is imposed, my lord.
Earlier costs you have not paid.
Earlier cost, my lord, everything, no, my lord, no cost imposed under the impugned order.
No.
Under the impugned order, no cost imposed, my lord.
There is no cost is pending before the trial court. Now your lordship has allowed the petition subject
To be paid to the husband.
My lord, no cost is imposed.
Future costs, whenever you are going to take adjournment, for that future cost you will be paying to the husband.
If I am free default only, my lord.
Yes, next.
Serial number 1, Vaishali Hegde for petitioner S.V. Prakash.
Give a date for this. Yes, next 2.
Serial number 2, Serial number 2.
No, what we do is eighth it is, we can take it on eighth. So all these matters on eighth. No, only RPFC fresh matters I'll hear from 7. Remaining matters give the date.
In my matter, it's covered by Rajesh's judgment. Madam.
Tomorrow.
So far as
Which is your matter?
Third
one tomorrow. RPFC.
Second matter.
Huh?
Second one.
Not 3. Third one. Second one.
Second.
Tomorrow.
Madam,
Yes.
serial number 8 is concerned.
Instead of that, I think I'll better call 3.
I'm for the respondent.
It can come on 8. List on 8. 4.
List on 8.
8.
Serial number 4.
5.
Serial number 5.
8.
Serial number
6.
6.
Happy for this.
8. 7.
Serial number 7.
I appear for the petitioner, my lord, 7. I appear for the petitioner, my lord.
Shall we take it tomorrow?
Yes, my lord.
7
Yes, my lord.
tomorrow. 8. 8 also tomorrow.
On 9th, your lordship.
Huh?
I am for the petition on 9th.
8 not
9th
completed
on
interim
9th.
order, my lord. They are not
Then
completed.
tomorrow, 8 should come tomorrow.
Yes.
Yes.
Number 9.
First
9 is
12
adjourned, I think.
9 is adjourned.
Your
Serial
lordship,
number 10.
tomorrow is,
Serial number 10.
I'm not available here, your lordship. I am out of
Appear
station.
virtually.
My lord, serial number
Yes,
10,
10.
my lord.
10.
Paid 20,000 rupees. My lord, the balance is 20,000.
It is adjourned. 9 is adjourned.
10, 10,
Adjourned in the
10,
morning.
10.
10. Huh.
Please. I paid 20,000, my lord. The balance is
We will
20,000.
see. We will see on 8th. Yes, 11.
Serial number 11.
Also 8th. 12.
12, I appear for the respondent.
8th.
Not on 8, my lord. 10th or
10th, there are matters. Then it has to be there. 11th. Next is 11th.
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 Please.
Next 13.
For the respondent, my lord.
13th.
8.
8th are already so many matters are given. 13th.
10, 9.
Yes, 14.
Serial number 7, 9.
24, madam. 24, this month, 24.
Yes, 24. Yes.
24, 9. Serial number 15.
15.
Chetanji. 7.
My lord's one submission. Serial number 13, cause this to my lord. Handle the.
How can you write that kind of an order? You are as if you have decided what is the order of the court.
I gave one more separate memo, my lords.
Hmm.
List number
ಬೆಳಗ್ಗೆನೇ ಆಗಿದೆ. కదా ಇದು ಬಿಂದಿಯಾಗಿ ಫೈಲ್ ಹೋಗಿದೆ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಸರ್ ನಾಳೆ ಬೆಳಗ್ಗೆ ತಗೊಂಡು